My lord, may I permit to mention one matter? But seeking a leave file without certified copy, my lord. When was the order passed? 6th March, but it was 6th March. It was uploaded in the server, my lord, 13th March. Did you apply for certified copy? Yes, my lord. Huh? Yes, my lord. 31st March you got it. It's served on 13th March, my lord.
My lord, if your lordship permits me, my lord, my case was fixed for hearing on 15th of March.
Yes.
Today it is on 134th number list, my lord. 134th in the list, my lord.
এটাকে না date fix করে দিতে। হ্যাঁ, আমি ওটা কালকে to be mentioned again. It will be there, yes, to be mentioned tomorrow. You please inform, you request Mr. Roy Choudhury to be here so that we can fix a date for completion of the hearing.
Grateful, my lord, but I had informed them 3 days ago, my lord. On 15th itself, I had informed. I have proof of that in my mobile.
The absence we cannot keep because they were in the midst of their argument.
My lord.
We are keeping it as to be mentioned tomorrow. You go and personally meet with the advocate concerned and request him to be here tomorrow so that we can specify a date and finish it up.
My lord.
Yes. Yes, there is a problem in this matter. There was an order directing the appeal to be heard along with the
Yes. Well, that petition, my lord, preferred by the appellant. Now, appellant is you want to, my lord.
You have to withdraw both.
Yes, both. Yes, my lord. Record it.
Okay, huh?
Yes. Kindly record it. Well, I have the power.
Lekho Mr. Hussain learned advocate. এখানে written আর instruction এ সেটা
নামগুলো দিয়েছি।
Mr. Hussain, learned advocate appearing for the appellant.
Appellant as well as petition number WP.
Appellant. Which petition was preferred by you?
Yes.
My lord, may I seek my lord's kind indulgence to mention?
What?
My lord, one matter, my lord, has been directed to be posted tomorrow, my lord. My lord, Mr. Mukherjee, learned senior advocate, appearing for the state is my adversary. Now, my lord, tomorrow I will not be available. If your lordship, my lord, kindly condone my absence tomorrow and may the matter be directed, my lord, on 26, 20, subject to convenience, my lord. My junior will mention, my lord, tomorrow.
Let him mention, let us see what happens.
Yes, I'm extremely grateful.
Mr. Hussain, learned advocate appearing for the appellant upon submits upon instruction that the
WP number 6673 of 2018.
এরম ভাবে লেখো records reveal that by an earlier order dated
15th November, my lord.
যে দুটো একসাথে শুনানি হবে এটাতে তো অ্যাপ্লিকেশনটা ডিসপোজাল করলে
The 15th November 2021.
records reveal that by an earlier order dated এইটাতে কি by an earlier order dated 15 November 2021, comma, and a coordinate bench of this
देखिए
court
सिबलिंग नामটা কি
had already disposed of the application being Can 1 of 2021 for condonation of the stop. Registry is thus directed to record such disposal of the said application. Stop. By the said order dated 15th November 2021, next one, comma, the writ petition being WPA number by the said order, it was 15 November 2021. It was also directed that the appeal shall be heard along with a writ petition preferred by the appellant being WP 6673 bracketed W of 2008. Stop. Today, Mr. Hussain learned the advocate appearing for the appellant stroke writ petitioner. What does it do? Appellant submits, comma, upon instruction that the appellant does not want to proceed with the present appeal as well as the said writ petition being WP number such and such. Stop. Let the written instruction, comma, as produced, comma, be kept on record. Stop. In view thereof, the appeal along with the connected application as well as the writ petition being WP number such and such are dismissed for non-proceeding.
Request, Your Lordship, Mr. Ikrimul Bari is appearing for the private
where
respondents.
yes
That's his name. Grateful, Your Lordship.
Grateful.
At least an advocate has to be present who is on record.
Lordship, I just wanted to bring it to your knowledge because his clerk was desperately wanting me to. Lordship, most probably the youngsters don't do it anymore. It's our generation which is continuing with this process.
So,
Non-prosecution, it has already no problem.
no non-prosecution of the appeal as well as the writ petition.
Yes, yes.
You are appearing for whom?
I am for the writ petitioner respondents in the appeal matter.
Each respondent. Respondent number. No. In the appeal, you are the respondent number.
Writ petitioner respondent, possibly my lord the.
Mr. Bari,
Huh?
Respondent number.
Huh?
You are for Shahidul Islam.
Yes. I'm for the Shahidul Islam. Respond number 8. 8.
Yes, next.
My lord, in this
This is my
matter,
application, my lord.
my lord, I am for the private respondents. My lord, on the last occasion, your lordship was kind enough to permit me to file the vakalatnama of all the 38 private respondents. Now, in course of that, we found that one of them had died. So I have made an application for substitution, my lord. Only thing is, my lord, I would pray, my lord, after considering this, my lord, kindly hears out the matter because many of them are in their deathbed, my lord. I'll have to make more substitution applications. So kindly consider this application for substitution, my lord.
Is it listed? Is it listed in listed?
Yes, my lord. It is
Your application.
No, application
Yes.
listed নয় বোধহয়
can number 1, my lord.
আছে can number 1 ছিল না কিন্তু লিস্টে তো দেখলাম আজকে লিস্টে নেই কিন্তু স্যার পেন্ডিং আছে সেকশন শুধু হ্যাঁ এই তো
আছে তো আমি তো ইয়েতে নেটে দেখলাম রয়েছে
আছে
হ্যাঁ
ওদের instance এ তো substitute.
So, Mr. Panda, it was incumbent upon you to file the substitution. They have informed on the last date, my lord, so that we could correct. We could correct the cause title they have said. But it cannot be corrected. You have to make an application substituting his. That I will do, my lord. Only one thing on the self-same issue. Another matter is pending before the Honorable Supreme Court, my lord. On the self-same issue, another matter is pending before the Honorable Supreme Court as regards ICR employees and regarding regularization of these casuals. So, I think, Your Lordship. It is pending. That was Supreme Court. ICR has gone.
Yes. Milord, ICR, Milord.
You know that?
My
I came
lord,
to know
that
today morning, my
judgment,
lord.
that
I came
is,
to know today
my
morning.
lord, in Guwahati High Court, my lord, an application was made.
No, that is
That was
the
dismissed.
tribunal
1
before
minute,
the
1 minute.
Guwahati tribunal
was
passed
the-
an order rejecting their application.
My lord, that,
Against that, they moved the Honorable Guwahati bench. There also they lost
my lord,
on the
this,
same issue. Then they have gone to Supreme Court. Since we are not there. Yes, two of the Kaiser persons were there.
no.
Yes.
That is
I have the judge. I have the copy of the
Probably,
judgment.
Milord,
I have
there
the
is.
copy. When is the Supreme Court matter?
Milord, probably there is a Milord misunderstanding. Milord, IACR Milord went up to Honorable Supreme Court. Milord, SLP was filed. SLP number is 14547 of 2020.
that was
In
filed
the
by
year,
private respondents
no,
who lost.
it was filed by the institute. Milord, it was filed in the year 2020. 2020 and matter when Milord was considered in the 2021 itself, and Milord issue notice was the direction on a limited Milord purpose for a limited purpose of Milord regularization, consideration of regularization of the workers, which is the self-same issue here. But Milord, I do not know what is the context of the matter, because I Milord through searching Milord I came up Milord just today morning. I came to know. Now, Lordship may kindly consider, Milord, the last January, Milord, matter was again listed before the Honorable Supreme Court, and the Honorable Supreme Court was pleased to direct that 4 weeks after it will come up and appear before the list. Now it is showing, Milord, from the case stated, it is pending.
But why this was not told to the tribunal? Tribunal order
Well, I do not.
2023. এটা কবে কার এটা সেটা বল ট্রাইব্যুনালে যদি the appeal has been preferred, the SLP was there since 2021.
Yes.
Why it was not
It's
pointed
2020, Lordship.
2020?
Yes.
Now tribunal has disposed it of on 2023. Why was it not pointed
My lord,
out to the
one more thing, my lord. It has been passed by a learned administrative member who could not have passed this order at all.
separate
No, that is also an issue.
I'll
If the
argue
court,
on
if
that.
the tribunal doesn't have jurisdiction,
I'll
the
argue
entire
on
thing
that,
goes. Entire thing goes, my lord.
You appeared, Mr.
I did not appear, my lord. Somebody else appeared.
This order would not have come since the issue was
Yes,
pending.
yes. Absolutely, my lord. Absolutely. It should have been pointed out. I think he was not aware of this.
My lord, we are not aware anything of this, my lord. There was not a whisper about this. There was no
Milord, it
whisper
was
about
Milord
this,
challenging the order Milord passed by Honorable High Court at Delhi.
We will allow this application, bring
Yes,
them on record first.
I should have filed it. They should have informed me, but however.
No, I have given him notice.
Yes, it is on record, my lord. So,
It's application for addition of.
yes.
And if any other person has expired,
No, my
Mr.
lord.
Sarkar, please give him the
No, my
particulars.
lord. Only this person, and I have done it. Why? My lord, let me explain. Only to expedite the matter, because many of them are.
Can we expedite when the Supreme Court is in CC of the matter?
My lord, not this matter.
My lord, there are exactly
Not
on the
this
similar
matter,
issue, my lord.
Nothing has been
As-
given to me, my lord. Not this matter. My lord, this is. My lord, kindly goes through the record. Well, this matter has nothing to do.
My
This
lord,
is
we come to find out that there are names
My lord,
of the
this-
widows also who
my
were
lord,
not
this
there.
matter.
Now suddenly their names have come.
No, my lord, this matter, my lord, is something entirely different. There was a special bench. My lord, kindly see the special bench judgment.
Is the pleadings are already on record?
I have,
Yes.
as per your
No,
lordship
no.
petition, we have entirely annexed everything with it. Like the mention. Oh, only the government of India would be saying something, my lord. My lord, there would be
Milord,
certain
Milord,
circulars
I'll be
which the
beseeching
government
your
of India
lordship,
would
Milord,
be
to
furnishing.
Milord, kindly
So,
allow us to Milord use an affidavit, because some documents are required to be Milord.
My lord, why after all this, he did not appear
he is
in
for the
the
Union of
tribunal?
India.
Union of India, Lordship.
Mainly
Yes,
the
for number
department
30.
who would be paying the
Haven't
thing.
appeared in the tribunal in the last 10 years.
Mr. Sarkar, we can hear you. Why you are so anxious? We will hear you.
Can 1 of 2024. This application has been presented to bring the legal heir of respondent number 22 on record. So, respondent number 22
14547
in course of
14547.
pendency of this
2020. Indian Council of Agricultural Research. This is Giriraj Singh Pal.
when expired,
When did he
Giriraj
expire?
Singh,
एक बार करो तो।
alias Giriraj.
12th November 2023.
Yes,
আপনার লাস্ট টেস্ট ছিল 5/1/2024 অ্যাডমিট হয়েছে হচ্ছে
Hard Mr. Sarkar and Mr. Chakraborty.
এটাও
The hard the lunch
তারপরে ওরা গেছে এটাও পেন্ডিং
লিস্টটা আমি দেখতে হবে
application is for income Mr. Sarkar learned অনন্ত দাস
দিল্লি হাইকোর্ট থেকে গেছে এই মামলাটা
his prayer has not been opposed by
has not been
opposed by Mr. Panda, learned advocate appearing for the
and also by Mr. Chakraborty.
I see here. You are for Union of India.
রেসপন্ডেন্ট নাম্বার 39
Respondent number 39.
39
Not been opposed by Mr. Panda, learned advocate appearing for the writ petitioner and by Mr. Chakraborty, learned advocate appearing for the
ইউনিয়ন অফ ইন্ডিয়া মিলর রেসপন্ডেন্ট নাম্বার 39
Mr. Panda appearing for the writ petitioners.
পার্টিদের মধ্যে দেখছি ক্যাটের মধ্যে
Application
নেই ঢুকিয়েছে কিন্তু তাই
can one of
যারা ছিল তারা অনেক আগে মারা গেছে
2024 allow
সেটা বলতে পারছি না তাদের মধ্যে দেওয়া
let the applicant be let the applicant be brought on record in state and in place of respondent number 22. So office is directed to make necessary corrections. Stop. So we have been informed that
Mr. Chakraborty appearing for the respondent submits that an identical issue is pending consideration before the Honorable Supreme Court. Stop. However, Mr. Sarkar, should I give the number? Should I give the number, SLP number? Being SLP
number
547 of 2020. 14547 of 2020. Stop. He prays for filing an affidavit in opposition to the writ petition. Stop. Such prayer is considered and allowed. Let such affidavit in opposition be filed within 2 weeks from date. Reply thereto, if any, be filed within a week there. Within 2 weeks thereafter. Stop. We have been informed that all the pleadings exchanged by the parties before the learned tribunal are on had already been annexed to the present writ petition. In view thereof, list the matter for final hearing in the combined monthly list of May. Application.
well, may I make one prayer?
Mr. Panda, if you find that somebody else has expired, you take appropriate steps so that we can finally let them inform us, my lord. Let them inform us.
Well, may I make one prayer? Well, this SLP, well, this was, we never knew about it, but not even before the tribunal.
Mr. Chakraborty, give reference.
Milord, I'll give the order sheets also. Milord, it was Milord.
Give a copy to me.
Yes,
SLP copy, Milord, I do not have, Milord.
your opponents are good persons.
Well, but here, yes, he is a good friend, but my learned friend appearing for the
So you
central
are-
government
you are
is a
such-
better friend of him.
You are very senior, Mr. Sudha. Everybody, they would be your good friends.
Only thing is, could the, my lord, the time for filing affidavits be reduced, my lord?
My lord, I was just
Because of this, my lord, my many of my clients are, my lord, in a
It
very
will be there in the combined list of May. Let the affidavits be complete in the meantime. You mention before us on May so that we can fix it.
My lord, I was just humbly beseeching your lordship, my lord, that my lord, if 2 weeks can be, my lord, extended, my lord, subject to my learned senior friend.
3 weeks, 1 week.
Because it is Delhi matter, my lord, it will come.
Complete it, Mr.
My lord, I'll do
We
that.
have an aged
My
person.
lord, I'll do that.
Yes, next.
I'm grateful, my lord.
May it please your lordship. Lordship, item number 4, 5, 6, and 7 are practically the same. Lordship, this is the case of land losers under the July 2010 notification, who are covered by the July 2010 notification.
So how you would agree, Ms. Mukul?
Lordship, what has happened is their land was taken in 2010. 2015-16, the land loser certificate was given. When the land loser certificate was given, some of them out of the 4, 2 applied in favor of their sons and 2 applied in their own favor. The 2 who had applied in favor of their sons, their case is not accepted because their sons were 35, 36 years old. And the 2 who had applied for themselves, they were later on told that you are overage, so they've applied for their one son and one daughter. Now they are saying that your son and your daughter, when the date of the land loser certificate, they were 17 plus, so we will not give it to them. Lordship,
Where is that?
Lordship, that is the, I'll hand over.
That
Give
is
me
why
that order.
tribunal has said that you pass
Lordship,
a
the
recent order.
tribunal has said that to pass a recent order.
Then
So
how
I
you are
came up.
by it?
I came up before your lordship that despite the tribunal passing this order, they are taking no steps. Now, pending this writ, they have issued a order. Pending the writ, they have issued an order, your lordship, where they have taken this stand. That when you applied, you were 36 plus, so I'm not going to consider you. And the other 2, they were minors, so we are not going to consider you.
You have to go to the tribunal, no?
Lordship, from 2010 till today, Lordship, 5 times we have been to the tribunal.
But what jurisdiction we have to interfere here?
Lordship has the jurisdiction because
of in a order passed, fresh cause of action.
Lordship, it would not, in my humble submission. Lordship, I will place one order before your Lordship, where your Lordship, the tribunal over-exceeded itself in its jurisdiction in similarly placed matters. Exceeded its jurisdiction in contempt proceedings. The court held that I will not interfere in the contempt has been wrongly done. They have traversed their jurisdiction, but in the interest of justice, since they are land losers, they are waiting for such a long time in the wings.
Well,
Consider
I
them.
appreciate Lordship. But I have also failed to understand which order is under challenge before your Lordships today.
No,
My lord, pursuant to
Okay.
tribunal's order, my lord, the tribunal directed to consider the representations
Give me that
and
order.
pass a speaking order. Accordingly, the speaking order was passed on 8th September 2023.
have you communicated?
Yes, that has been communicated annexed to this writ petition, but this order has not been challenged if they are at all aggrieved.
Lordship,
So
this
my
was
humble
passed-
submissions, my lord, absolutely correct, my lord. Let them, if you have fresh cause of actions, let them challenge that order if they are aggrieved at all.
We understand that,
Lordship.
Mr. Nondi, but as you are appearing, railways have in most of the cases only
Lordship.
day before yesterday also that this point is no longer agitated. All right, if the person is an aged person and it has not been considered, his son would be called for document verification.
Lordship.
That had been the stand.
Yes.
If that is so, Mr. Nondi, we shall record that and dispose of
No,
it.
here, my lord, the final order has arrived at.
Where is the final order?
That is
Lordship,
at
this
page
is-
95. Page 95, where now the stand taken by railway authorities, Eastern Railway, that this earlier land loser scheme or the policy has been withdrawn subsequently in 2019 with effect from with effect from 11th November 2019. So therefore, they are now coming within the scheme of this land loser scheme. So what is the new policy? I am also placing everything, Milord. The new policy is that one-time compensation that has been paid to them. Well, at page 95 is the fresh speaking order in terms of tribunal's last directions, Milord. Let me place the enter speaking order. So, Milord, at page 96, it starts from page 96. In compliance with the orders of the Honorable Calcutta dated so and so, in way number 6 in the matter of Subhash Chandra Bauri versus so and so, official.
You have to challenge this before the
Lordship.
trial.
Lordship, after that we have come to the we have gone to the tribunal, and tribunal has directed them to consider our case. Because your Lordship, we do not come under the 2019 circular.
No, this order was 8th of September 20.
Lordship, we do not come, and I have taken up this point in this appeal,
Right,
that
but
we
how
do not come under this Lordship, they
That
cannot.
you have to agitate
Yes.
for the tribunal, na?
Lordship, that
It's a
would
fresh
again,
contract.
Lordship,
Little
that
final.
would again, your Lordship,
This one.
incur time.
Challenging.
And those who were minors in 2015, by the time the tribunal goes through that matter and we come to a conclusion, Lordship, they would also become overage. Lordship, Lordship, may I please just
Can
one.
we decide the issue? Can we decide the validity of the order?
Lordship, if on prima facie reading of that circular, if your Lordship can come to a conclusion, because that circular specifically states it will come into
This is,
effect in 2022.
This is something bulldozing into the jurisdiction of
Lordship will kindly
Assume jurisdiction right now.
we will hear you, but I think you should apply your mind to this and go back to the tribunal. Why you are inviting
Lordship only
not
on
refusal on our
Lordship only on one thing. Only one thing, your Lordship,
Yes.
I was praying. Lordship, I'll just place one judgment before your Lordship. Lordship will come to page 100.
100. Page 100.
Page 100.
Lordship.
Yes.
Lordship, this is a judgment.
This is a yes,
This is a judgment, Lordship, passed.
we know this
Yes.
judgment.
Lordship,
Guideline.
We have also passed order.
Lordship, in this judgment, your Lordship, what has this honorable court done?
Exactly. So that is a ground for you to be taken up before
Lordship,
the
this
tribunal.
honorable court,
We
in my
cannot decide.
Lordship, in my humble submission, this honorable court holding that the tribunal had no jurisdiction to pass an order. The honorable court held
Where
that
is
the
that?
Lordship will kindly come.
What was the order impugned? Was there any
Lordship, the
passed?
order impugned was an order passed in contempt. And
No. This page 100 is in the WPCT matter.
Lordship, in this matter, Lordship, the order impugned was an order passed in contempt.
Yes.
Lordship, and what did the court hold? Lordship, may I take your Lordship to page 105? Page 106. Lordship will kindly come to paragraph 17. Law is well settled that while hearing an action for contempt, the tribunal's scrutiny ought to be confined to certain whether its order has been willfully disobeyed. If yes, it ought to ensure proper compliance of the order alleged to have been disobeyed. If an order has been passed by the tribunal for consideration of the claim of an applicant before it, and an order has been passed thereafter rejecting the claim, the element of willful disobedience may not exist, and it is normally not open to the tribunal to exercise its contempt jurisdiction to examine its validity as if it were a court of judicial review. So, Lordship, that was the conclusion which this honorable court came to.
That is in connection with the contempt.
With a contempt. And then, your Lordship, where did this court go on? Your Lordship will kindly come to paragraph 19. In Sudhir Vasudeva has reiterated the settled principle of law that while disposing a contempt application, no order can be passed by the court or the tribunal, which in effect adds to or subtracts to alter the order which the contempt is alleged. In that view of the matter, we have no hesitation to hold that the order impugned in the teeth of the decision of Sudhir Vasudeva and being one passed in excess of jurisdiction, the same cannot be sustained. It is set aside. Lordship, after setting aside the impugned order, the court has granted relief to the private respondents.
But how that
only on the ground, Your Lordship, that being land losers, they should not be. Lordship, from 2010 till today, we have filed as many as 5 applications before the tribunal. Lordship, first application we filed before the tribunal, they took up the ground. That time, Your Lordship, they did not take up this ground.
A question. We understand the prejudice suffered so long years of pending litigation. But unfortunately, we cannot interfere here. This will be a good ground of your argument before the tribunal. Because on the basis of this judgment, series of orders were passed that you consider his claim afresh, or if you have not considered it in the light of this judgment.
Lordship,
but that, Ms. Mukherjee, we cannot pass.
I totally appreciate your Lordship. Lordship, we
We will
consider
give
just
you
one
liberty
prayer.
to withdraw the same and to challenge the same before the learned tribunal.
Lordship, we consider one thing. Lordship, should we allow the authority to play the game of the wolf and the lamb? Lordship, here...
Now, what is the problem we will tell you. Now, once even persuaded by your argument,
Lordship,
if we admit it also, they will file an opposition. Matter will come up for final hearing. That will also take time. In the midst thereof, it will be more advisable, subject to your correction, that you should approach the tribunal instead of...
Lordship, may I just place one thing before your Lordship? Page 50.
No, then we pass an order
I'll leave it to your Lordship's discretion if your Lordship will admit it at all or not. Kindly come to page 50.
No, we will give you the liberty to challenge the same before the tribunal.
Lordship will kindly come to page 50.
Was passed. This order was communicated to you in September 2023.
Lordship.
So they will, if you pass that, they will hear the matter on merits. If the limitation
Lordship, because we will be opening a new Pandora's box if this is allowed to be agitated before the tribunal. Lordship will kindly come to page 50.
Page 50?
50, 50.
But this is the new policy.
The new policy,
It has not been challenged.
I come to your Lordship kindly, and your Lordship will kindly come to page 51. Lordship, the last line of this policy shall be effective from the date of issue of this letter. Lordship, my right accrues in 2010. And this is a policy of 2019. Can they give this policy a retrospective effect to my claim?
So who will consider?
Lordship will, because I am before your Lordship on an order passed by this tribunal, where this tribunal has asked them to consider my case under the 2010 policy. And your Lordship, in deciding the 2010 policy, they are again trying to sidetrack my merit by resorting to a circular which is not effective. Lordship, this is the wolf and the lamb. We open a new Pandora's box where these land losers are concerned. And then, your Lordship, they will go into the ages of this 2019 circular, and they will find a new ground to dismiss my claim. And your Lordship, by the time it is adjudicated, they'll come with a new policy. Every time, your Lordship, the land losers come before your Lordships give them some relief, they come up with a policy. Should that be permitted, your Lordship? Lordship,
which page you showed us? Page policy that 2000.
Which page did you show?
Which one? Page 50.
No, your page, the one which you were referring to.
That is, I have not referred anything right now.
আরে আমার পেজে তুমি যেটা দেখালে এক্ষুনি order pass করে দিয়েছি.
Oh, that is speaking order 95.
Page 95. Lordship, they are relying on page 95. They are relying on page 95.
Let them challenge me.
সেটা তো কমপ্লিটেড অর্ডার, সেটা ঠিক।
Will not disturb your lordship.
But Mr. Nondi,
Lordship.
tribunal's direction was you considered in terms of 99
16-7.
RP. On the face of it, then how you could have passed the order placing reliance upon a subsequent policy decision?
Well, the railway authorities, while passing off this speaking order, also consider 2010 policy. But while they considered, in the meantime, that policy has been withdrawn. New policy came into operation.
Tribunal directed you to don't consider any other policy, go by the earlier.
Lordship.
This is on the face of the record, it appears. If you cannot satisfy on that issue, then the very order goes.
No, but since this order, even the speaking order, even not challenged before your lordships today.
We need not have.
Now, the speaking order which has been passed, Mr. Nondi, is passed in terms of the compliance of tribunal.
Lordship, it has been mentioned there. 23rd December
Tribunal
2020.
has said that you considered it in the light of the 16 July 2010 circular. Kindly come to internal page 3 of the order.
Yes. But
3. Circular which was referred to as 16th of July.
Lordship, 16th July so and so,
Come to
another was
paragraph
issued
3.
by railway authorities and submitted so and so and applicant. But this is the submissions recorded. Now, the ordering part.
No,
That
no,
is,
yes, ordering part 3.
is considering paragraph 5, considering the above submissions without expressing any opinion on merit of the claim of the applicant, we deemed it fit to dispose of this way at this stage with the directions upon the respondents to consider the pending representations of the applicant. So, tribunal, yes, if not already decided, if considered, in the light of the circular referred to herein above,
Yes.
along with the extant rules and policy in vogue, as well as the various orders passed by the tribunal and the Honorable Court, High Court, with respect to identical claims, it is expected that the competent authorities shall consider within 90 days. So, here tribunal didn't fix any limitations. So, said in terms of the policy in vogue as well as various orders. So, policy which was on vogue as on the date of consideration, we had taken into consideration.
Lordship, can they do that?
So, as on date of considerations, the new policy came into operation with effect from 11th November 2019. So, accordingly, this order has been passed. If they are aggrieved, let them file and fresh applications. The policy in
তারপরে চ্যালেঞ্জ করে হয়েছে ওটা চ্যালেঞ্জ করা হয়েছিল। হ্যাঁ, কি হয়েছে ওটা কনসিডার করার জন্য পাঠিয়ে দিচ্ছি। মানে ওটাকে চ্যালেঞ্জ করে ট্রাইব্যুনাল চ্যালেঞ্জ করেছে। এখানে সিন্ডিকেট অর্ডারটাকে চ্যালেঞ্জ করেছে। হ্যাঁ কনসিডার করে। হ্যাঁ
clear with similarly
But
placed
Mr. Murthy,
identical people.
if you are adopting the policy in cases where the person can be, this is not a new application.
Lordship.
This has been pending.
Lordship.
In the other matters which you have appeared, this we said that all right, whatever be the merit of the application, why don't you take this instruction as to whether they would be called for the
Document verification. Lordship.
Since on the issue, this age bar issue has been previously considered.
Lordship.
So if you apply your good office, at least they can cut short the litigation by 5 years and get a call for document verification. It is not that two persons are claiming for the job. We will record that it is not a case that the father is aged. Now 5 sons will apply for compensation. We will yesterday only we have disposed of a matter.
I have heard it. Mr. Roy was there.
Mr. Roy was there. So if you take this instruction at whether they will get employment or no, we do not. But this anxiety to continue.
I appreciate the anxiety of your lordship and what is following for your lordship's mind.
If your
but only thing, kindly hear me for a moment. My responsible submissions, that authority was the Eastern Railway Authority, and here, Southeastern Railway. And this petitioner here, the respondent is Eastern Railway. Eastern Railway did not adopt that policy. Eastern Railway is going in separate way, in their separate way. They have initially they had accepted 2010 policy. Subsequently, it was withdrawn in 2019. But Southeastern Railway is continuing with the earlier one, 2010 policy.
How can we two frontiers?
Yes, I have also inquired from the railway authorities. They had given me 2 instructions. The railway board, they obtained the permission from railway board to make it differ.
No, Mr. Nandi.
Why you will whether it is challenge or
Lordship, if I was to go before the tribunal, I would have to file a contempt.
No,
And
no,
if
why
I
contempt?
because your lordship will kindly see the order which was passed by the tribunal. The tribunal passed a very clear-cut order. Your lordship will kindly see paragraph 5.
As well as the circulars in
Lordship,
vogue.
the tribunal says the extent rules in vogue as well as various orders passed by the tribunal of the High Court with respect to identical claims. So, Lordship, my claim is under the 16 July 2010 circular. And your Lordship, the circular of 2019 is very clear.
After, suppose out of, there are 4 writ petitions.
Lordship.
If you come with this instruction that, all right, there can be a document verification, then we will leave it.
Lordship.
And suppose you say that, no, we stick to our original decision. In that case, we will decide whether we will whether we will admit or we will send it back to the tribe.
Then kindly decide it on merits in that event.
No. Suppose upon instruction you come and say.
No, document verifications maybe it is they will be called upon for
document verification. We will record that no further employment will be claimed. As such, the son or the daughter, whoever it is, will be called for document verification. If that stage is over, that we dispose of the matter. We will not keep it pending. But if you say that no, it has to be by the new policy, nobody can be called for documentation, as is your
stand today.
Harshan, you have stated
stands today.
Speaking order.
Yes.
In that case, we will decide whether we will continue.
Very well. I appreciate it. Then kindly decide that matter in that event.
Your good office.
Very well. I'll inquire from my client, sir. I'll take instruction.
Item number 6. I am appearing in item number 6. There is basic difference in the item number this matter and item number 6.
What item number 6?
Mr. Noti, you are appearing in which matters?
Item number 4 and 5. These are 2 similar matters.
4 and 5.
Kindly pass one line order at least what is following for your lordship and the query is raised. I am to satisfy to your lordship also.
তাই জন্য শুধু তাই জন্য না ভিডিওটা পাচ্ছি
Now, who you are saying will should get appointment? Your son and
Lordship, item number 1, my daughter, Suchitra Barui.
Acha, Hard Miss Mukherjee, learned advocate appearing for the petitioners. Mr. Nondi, learned advocate appearing for the respondents, is directed to avail instruction as to whether the petitioner number 2 can be called for document verification.
Lordship.
Hmm?
Lordship.
Necessary. Acha, Mr. Nondi, we will not embarrass you. Mr. Nondi, learned advocate appearing for the respondents, is directed to avail necessary instructions. Is this matter for further consideration under the heading to be mentioned? When can you come back?
But after 2 weeks, I'll come because kindly add one more sentence. But what was the order right now passed earlier? Kindly keep it in that way to take instructions from the client or the railway authorities whether document verifications would be this stage would be made for the in respect of the petitioner number 2, or they will stick on the policy, or they will stick on their policy as on date. That will be more convenient for me also. Otherwise, it would be impediment for me to convince my client.
No, if we say so, our
Lordship, it
direction
will be-
becomes contradictory.
Lordship.
Because you have
No, but instructions I can seek. What is the questions raised by this honorable court? That may be turned into the instructions which may be short from the litigants or my client even. So what is the query from the court that we can on that basis I can seek instruction.
Submission.
that query has been
It
rejected.
is their submission, Your Lordship.
Lordship. That is one of the point here.
Lordship, that is their submission before Your Lordship.
My submissions, this previous policy does not exist.
Lordship, it will be
Speaking order has been passed. New policy has come into operations. They did not challenge the new.
Take a decision contrary to the decision they have already
Yes.
taken. This is the point.
That would be very embarrassing for us also.
All their own decision.
Lordship,
Recall
that
they have
is that
Already
the decision
final
before
order
Your
has been
Lordship.
passed.
The tribunal has passed an order, Your Lordship, specifically
Oh, sorry.
that you consider
Better, my lord. I'm suggesting to my lord, my London friend.
Insist that it has to be heard, then
Yes.
we will keep it pending. He will file.
I'll
it.
file an affidavit accordingly.
We were
This
giving
is
you
just
an
a
option.
point of Lordship, I don't see on facts as any affidavit to be filed. Let us
Cannot prevent them
make
from
a submission
filing.
on law.
As we are not, this is simply dragging the matter for substitute.
Lordship, if I
Simply
go
that.
back to the tribunal challenging the 2019 circular, Lordship, that would be
No, that is your
that would be opening another Pandora's box, Your Lordship, for where these land users are concerned.
Learned advocate appearing for the petitioners. Mr. Nondi, learned advocate appearing for the respondents, praised for leave to file an affidavit in
Within 3
opposition
weeks.
to
Lordship,
the
2 weeks.
file an affidavit in opposition to the lead petition. Let such affidavit in opposition be filed within 2 weeks. Stop. Reply thereto, if any, be filed within a week thereafter. List the matter for further consideration. 4 weeks hence, under the same heading. Under the same heading. And in the meantime, Mr. Nondi, apply your good office. If you find that
if there is any possibilities
then please
to consider,
please give a notice to her and come and mention us. We will,
I shall definitely. It is my responsibility.
same order করে দেবে next matter. And 6 also, you come file your opposition.
The problem in respect of 6. After the order of the tribunal on 23rd December 2022, the authority has not yet passed the speaking order.
Have not yet passed.
No.
Very good. You file your opposition.
So, my lord, may I suggest one thing, my lord? Let the matter be disposed of, my lord, and the authority will be pass the speaking order, my lord.
Pardon?
After, my lord, the order of the tribunal, they have made a representation before the authority to pass the speaking order.
So, have you passed any order?
No, my lord. Order
Then
has not.
when you will pass? When you will
My lord,
pass?
due to the pendency of this matter, my lord, they have not yet passed, my
Is
lord.
this an excuse you are giving? Pendency of this matter, I will not pass my order. When was the direction given? Much earlier. Others have done, you say during pendency. Don't make this sort of submissions, Mr. Bose. So what is your instruction? What do you want to do? Tell us.
My lord, my instruction is, my lord, they will pass the speaking order, my lord.
Lordship will be in the line of the same order because same authority.
Item number 6, Tada.
And my lord,
Is preventing you to pass. If you pass, you enclose it in your affidavit.
In the affidavit and opposition.
If you pass in the method, you enclose in your affidavit.
my lord, in my case also,
Suppose you file your affidavit. In the meantime, if you pass the order, you record that in the give a copy, include that copy in the opposition. Same order.
I'm grateful, Your Lordship.
and my lord, that liberty may be given one line, kindly add one line that, my lord, in the meantime, the authority can pass the speaking
is
order.
not required if I'm not mistaken.
My lord,
Have we stayed the order? Yes, next.
না, না, সেটা হচ্ছে order. My lord,
In 7, Mr. Ghosh, you are in 7.
সেটা হচ্ছে তোমার order. My lord, kindly that liberty may be given to my lord so that my lord authority can pass the order in the meantime, my lord.
You are acting in contempt and High Court will ratify your action. That all right, you have delayed. Sleep for some more time and come. Yes, next item 7, you are there, Mr. Ghosh.
In item number 7, DNRI is appearing on behalf of the respondent.
Same order,
Same
similar.
order, same,
Order
same.
has been passed.
Lordship.
Same order. Item number 7, ওনার নামটা দিয়ে দিন। What is your name?
My name is Saurav Haldan.
You are with Mr. Roy.
No, my lord. My senior is DNRI.
Your senior is Mr. Give your name then.
I've given my name.
Yes. Yes,
Grateful.
next.
I'm grateful, Your Lordship.
I am for the respondent, ma'am.
8 Milord, we are for the fix. We have already served Milord.
Yes, I am for the respondent.
This is our affidavit of service.
So, yes, the parent order was passed in another original application.
Yes, the parent order was passed in another original appeal, original application. Some other successful candidates, Milord, before the principal bench in Delhi, similar issue, Milord, they preferred another original application. Simultaneously, our clients, they filed original application before the CAT Kolkata, Milord. Now their matter previously decided. So that judgment is relied upon in our case. We have challenged the
No, we are asking this OA 1702 order of 2023.
Yes.
This order must have been challenged by the applicants there.
Those are different applicants.
No, has it been challenged?
No, as per our instruction, no appeal has been preferred in Delhi.
No, this OA 1702 recorded in the order. Your matter has been disposed of on the basis of the order passed in 1702.
1702.
So we are asking you,
yes,
has you challenged this order?
Through this Calcutta's order, we are challenging the Delhi's order, Milord.
No, I am clarifying this position. Actually, on the self-same cause of action, another application was filed before the Delhi head bench, my lord.
This OA is of
a Delhi's order.
Delhi's order.
On the same issue, identical issue. And the Delhi bench has decided and rejected the application, holding that the decision of the CBI is correct. And since the same issue was involved here, the order was placed before this tribunal, and tribunal, upon taking into consideration of the Delhi court order, my lord, has dismissed this application.
Right. Now the Delhi court order, which was passed, whether that was challenged before the High Court of Delhi? Do you
No,
have any instruction?
No, as per our instruction, no appeal has been preferred in Delhi High Court.
Then what is your prayer today?
Our prayer is, my lord,
you are challenging the same order of
yes,
18 December.
We are challenging the same order, my lord. Kindly, my lord, consider the background of the case, my lord. The respondent CBI, my lord, they decided. Yes. My lord, may kindly consider this list of dates.
Delhi High Court order.
Yes, Delhi High Court's order and list of dates, my lord.
Delhi Tribunal order.
That is already in there. That is already in there.
234. It starts from 234. Lordship ke bol.
235.
হ্যাঁ নিচের কোটে অর্ডারটা
ওইখানটা আমি দিয়েছি, ওটাই হচ্ছে মেইন অর্ডার।
তাহলেই হয়ে যাবে, তাহলেই
Where is this order of 16th May 2023 challenged in the Delhi Tribunal?
16th May 2023, that is, my lord, page that is, my lord, page 94. Page 94 of the, my lord, my application. A short list of dates I have already handed over mine.
Tell us the fact, what has happened.
Yes. Kindly, my lord, see my short
the selection process of 2020.
2020, my lord. They, well, kindly.
What interim order you are seeking now? There is no scope for any
interim order. The reserve, they have already joined. New candidates have already joined, my lord. So the result, they are joining, maybe abide by the result of this writ petition, my lord.
They are not parties here.
No.
So kindly direct us, we shall make them party. In the meantime, we shall make them party.
Page 253 is the order, my lord, appointing the newly selected candidates.
Your written, the written examination was conducted in 11th of September 2021.
2020.
For 11 sub-inspector posts.
Yes.
So LDC has been cancelled. In that you participated.
Yes.
It has been decided to hold a fresh written examination. That was held. Fresh written examination was held. Did you participate there?
No, I did not participate there.
Selection is over. Appointment is over. Appointment is 253 page. Order of appointment of the newly selected candidates.
253.
253.
The day, my lord, order passed by the learned tribunal, the next day they have joined, my lord.
Order passed by the tribunal was on 18 December 2023.
And 19th, no,
21st January 2024.
21st January
24.
They have already joined.
They have
joined after passing the CAT Kolkata's order, my lord.
Kolkata's order was passed on 18 December 2023.
No, Kolkata's order was passed on 19th January 2024.
No. Where is that?
No, order was, my lord,
18th of December.
18th was December order passed, but order was supplied and uploaded to the.
That is different.
Now, in the tribunal, they exchanged their pleadings.
Yes, everything. The only issue, my lord, whether the tented and non-tented candidates may be segregated or not. Our humble submission is, my lord, there were 11 candidates. Among 3 of them, they are alleged beneficiary of cheating. So the cheating, paper leakage. They are alleged beneficiary of paper leakage. But no concrete evidence is there against them. So the learned tribunal held that the tented and non-tented candidates may not be segregated. And they have held for
the Delhi High Court.
Delhi CAT. And they directed for fresh examination.
So in this writ petition,
yes,
unless you make them parties,
exactly,
how can you get their appointment cancelled?
We shall make them party.
That becomes very complicated.
We shall make them party. Kindly grant us liberty, we shall make them party.
That is your choice. What?
Well, leave may be granted.
Yes, leave may be granted to make them parties, my lord.
What leave?
Now, the appointment was given in terms of the order passed by the Delhi Tribunal.
Delhi Tribunal. But previous, we are the successful candidates, my lord. Appointment letter was issued in our favor. We gone through the medical examination. Relieving order was also there. After that, my lord, suddenly one notification was issued that our appointment must be kept in abeyance. After that, for nearly more than 1 year, nothing happened, my lord. Then we filed one original application. During pendency of that original application, after more than 1 year, suddenly one notification came out that previous examination is cancelled, my lord, and fresh re-examination may be conducted. So we filed.
Sir, you make up your mind. If you say that in their absence we can hear, because you will be vouching for the post which they are occupying.
They are occupying, yes.
And their occupation has started subsequent to the dismissal of your application.
Our application.
So now if you say that the entire selection process has to be cancelled and we must be given appointment on the basis of the earlier
examination,
then they would be prejudiced.
Yes.
Unless you bring them on record, how can you substantiate this point? It is your choice. If you say that, no, I do not want to engage, I want implementation of the earlier order, that is up to you to decide. We cannot advise you.
Clear order implementation
We can adjourn the matter. We can adjourn the matter saying that you would be taking appropriate steps. That much we can do. Otherwise, or we can admit this matter and fix it for
admit the matter.
Admit the matter. We admit the matter. In the meantime, we shall take an appropriate step. The issue is not very small issue.
Yes. Yes, yes.
Only basis of mere suspicion.
Leave down.
The present writ petition has been preferred, challenging an order dated 18th of December 2023, passed by the learned tribunal in the original application being OA. You are in which OA? There are two ways where
in two original applications, I was the applicant.
350,
730 and 637 and 730, both the original applications. But one combined order, both the applications was dismissed.
No, I think they should be on record. Then the question of admission will come.
Very well. Good.
Mr. Bhattacharya. In room lecho.
কিন্তু সবাই তো ট্রান্সফার হয়ে গেছে, সবাই এদিকে ওদিকে জয়েনিং করে ট্রান্সফার করে দিয়েছে, আর 70% লোককে তো জয়েনিং করে ট্রান্সফার করে দিয়েছে। এর মধ্যে থেকে 70%
But only one thing, Milord, we may not be able to get the addresses of all the newly joined candidates.
No, you are saying that to get an order of abide by the result of the writ petition, unless you bring them on record, question of passing such an order does not arise. And today, if we admit it and fix for hearing, even after you add them, you cannot pray for this interim order. Understood? This is the problem. So now the ball is in your court. If you want to bring anybody on record, that is your choice.
And Milord, kindly direct them to supply the addresses of the newly joined candidates, Milord, because we do not have
that is up to Mr. Bhattacharya to decide.
I shall try. I'm Lekchi.
আচ্ছা, লিখো। What is your name?
চিরন্তন সরকার।
হ্যাঁ,
চিরন্তন সরকার।
Mr. Sarkar, learned advocate appearing for the petitioners, prays for an accommodation to take necessary steps in the matter. Stop. Mr. Bhattacharjee, learned advocate, enters appearance on behalf of the respondents. Stop. Mr. Bhattacharjee, পরে দেখ। এরম লেখো, prays for an accommodation to take necessary steps in the matter. In view thereof, let the matter go out of the list for the present. Stop. Liberty to mention, with notice to Mr. Bhattacharjee, learned advocate, who has entered appearance on behalf of Union of India.
Union of India.
Affidavit of service.
My lord, may I submit one thing?
Yes.
If my lord kindly make a note that Mr. Bhattacharjee may take steps to provide the names of the candidates appointed, names and details, it would be very helpful to us, because otherwise, if there is no order, if I ask them to provide the names, they will not provide us the name. Just one line, just to add one line. Just one line.
They are working in your office, Mr. Bhattacharjee.
Yes.
They will serve upon the office concerned where they're
But
working.
the address that is mentioned here, my lord, they are already transferred. They have joined in various offices, my lord. It is all India basis. They have joined throughout the India, my lord. So
you know where they have joined.
No, there are 11 candidates, my lord. Some have joined in Nagpur, Guwahati,
Unless
Delhi.
you make the application, how can we ask Mr. Bhattacharjee to provide the names? You have to decide whether you will bring them on record or not. Yes. If their address is not known to you, you have to give a formal notice to the office that intimate the address of this gentleman. Or you take the help of Mr. Bhattacharjee after if you file the application. Yes. ছেলে না এই ছেলে ছেলে
My lord, I am appearing for the petitioner, my lord. I am relying upon my lord judgment order. Page 94th. In complete parallel case, my lord, your lordship passed the order in 3 matters. I have annexed.
Right order or wrong order?
The right order. My lord always pass the right order. Page 94. 94, 95, 96. And
we have done 94 page initial.
Annexure P4.
Oh, that army tribunal?
Army tribunal, my lord. I am relying upon this order, my lord. There is earlier there was a direction to file informal paper book, my lord. In the meantime, there is a stay.
Yes, what do you say?
Your lordship, I am submitting the prelim objection before your lordship, written objection on the grounds of jurisdiction. On the grounds of jurisdiction, your lordship, kindly, I beseech your lordship to.
No, have you seen the order passed in respect of similar matter, page 87?
Yes, your lordship.
We will keep the maintainability point open for you. Let them file the paper book. We will keep the maintainability point.
Obliged.
But we have to, this interim order has to be passed, now, since in similar matter. Or then you place your case.
Yes,
Mr. Chobe, please.
My grounds of objection is that since the as per rules sub rule 2 of rule 6, your lordship kindly comes to sub rule 2 of rule 6 of the Armed Force Tribunal Act. I am talking about.
Tribunal Act, do you have a copy?
I have. I'll kindly lordship.
Now, what are the facts? Tell us. Are you identically situated with these two persons? Ratan Samadar, this is for disability pension. The matter for disability.
Yes, my
lord.
lord.
Matter for disability pension.
What the tribunal held in your favor?
The tribunal held in my favor, your lordship. That is what kindly your lordship comes to that Sub rule 2 of rule 6. That sub rule 2 of rule 6.
Yes.
It says that a person who has ceased to be in service by reasons of retirement, dismissal, discharge, release, removal, resignation, termination of service, at his option, file an application with the registrar of the bench within whose jurisdictions that such person is ordinarily staying. Now that person is ordinarily staying in the at Odisha. So, your lordship kindly comes to, I have annexed, now I would like to draw the attention of your lordship towards section
Where did you file the application? Where did you file the original application?
I have filed the original application before the Armed Forces Tribunal Bench, Kolkata, because it is within the jurisdiction of the Kolkata. I have annexed the gazette notification that which says that it should be filed. Now, my humble submission.
Then the matter went up to Supreme Court.
No.
In some cases.
Yes, my lord. Kindly see para 7.
In some cases,
my lord has have the power of judicial review. In my para 7, page 4. The petition submitted on account of law declared by the Honorable Apex Court in Union of India, Purushottam Das.
This finding was on the basis of an Purushottam Das.
Purushottam Das.
Yes, have you seen that judgment?
Yes, I have seen, your lordship. I have also annexed one judgment. Your lordship, kindly, I will come to the statute first, your lordship. That part we will come on the judgment part later on. Let us come to the statute first. Now, your lordship, kindly comes to subsection 4 of section 5.
Which section?
Subsection 4 of section 5.
Yes. Yes.
As per this subsection, the jurisdiction means
First tell us, how does your case come under 6(2)? Yours is not a case of dismissal or removal or discharge. Your claim was give me disability pension.
Yes, so he is released from the service, your lordship. So all the retired, he is already retired from the service. So that comes under the that comes within the sub rule 2 of rule 6. Now, as per subsection 4, section 5, page number 19. Just I have annexed a gazette publication also. Your lordship kindly comes to now my preliminary objection, page number 19. Now this gazette publication, your lordship.
Yes.
Your lordship, now your lordship, I beseech your lordship kindly comes to running page number 19, annexure R2. This is the gazette publication, Ministry of Defence. Now this says that the Tribunal Kolkata with effect 23rd day of November 2000, which shall have the jurisdiction of the territorial limit in page number 19, your lordship. I have 19.
Of this writ petition?
No, not this writ petition. I have submitted the prelim objection. I have given the. Yes. The lordship, page number 19.
Yes, page 90. 90. Have you given a copy to him?
Just received, my lord.
Just now.
Just now.
Go through it and come.
Then my lord, keep it next Wednesday, my lord.
Let me check.
Otherwise,
You are coming from
no, Calcutta.
No, I am from Calcutta, Your Lordship.
You are from Calcutta. Then you don't have any problem.
I have matters at the courtroom as well before this honorable court.
My lord, may I submit in this? My lord,
29.
may I submit this?
29.
This speaks, my lord. AFT Kolkata have the jurisdiction of the states of West Bengal, Bihar, Jharkhand, Odisha.
Where you are reading?
Page 19, my lord. Their preliminary objection.
He has not finished. We stopped him because it has been given to you just now.
Then keep it, my lord, on Wednesday, my lord. Next week.
Very good.
In the meantime, stay.
If it is not maintainable, how can we grant this stay? You satisfy us on that point.
Very well, my lord.
Or we can keep the maintainability point open and admit the petition so that all can be heard. Or if you want a substantive hearing on that point, we will fix it.
It is up to your lordship. Whatever your lordship takes their discretion.
Up to us, it is your choice. Because you are suffering an order. Because today, if we pass an order of interim order,
no, kindly keep stay. Let the matter be fixed.
No, if you are
my judgment is delivered in the year 2023.
Where is the order of the tribe?
Order of the tribunal, my lord. Page notable. He is not discharged on the medical ground, my lord. He is discharged on superannuation.
He is on the medical ground.
Not medical ground, my lord. I'm 102.
After 102 certificate copy, na? After 102.
102.
Well, after
Your lordship, let another date be fixed. I have submitted my written preliminary objection. Let my learned friend to go through and then.
This notification has been issued in terms of subsection 4 of section 5.
Subsection 4. Your lordship.
Subsection 4 and section 5 go to subsection 4 and section 5.
এটা এখানে বই নেই আর What is you are Mr. Singh?
Your lordship.
Kindly come to the notification. It is page 19.
Yes, I have. I am here.
In exercise of subsection 4 of section 5, which you showed us.
Your lordship.
The notifies the bench of armed forces Kolkata with effect on which shall have the jurisdiction within the territories of West Bengal, Bihar, Jharkhand as well as
Odisha. So my submission before your lordship is that since the respondent is from the Odisha, so the appropriate jurisdiction lies with the Honorable High Court, Odisha.
No, my lord.
No.
How? Here the original application you filed in Calcutta. You filed the application in Calcutta. You didn't file it in Odisha.
Reason being, that is what I was trying to draw the kind attention of your lordship in the sub rule 2 of rule 6.
It is rule, but it is notification is under act.
Your lordship, rule.
Rule is saying where in which place the application was presented. But this notification issued by the central government, being empowered by the act. What is your
my submission? My only submission is that since the respondent belongs to Odisha, since there is no bench at Odisha, so jointly there is a means considering all the states factor, this AFT Kolkata has been constituted. Now, since he is staying at Odisha, so Honorable Odisha High Court is the appropriate jurisdiction. Because
in connection with what he will fight. he will approach the Odisha High Court challenging the order passed by the Kolkata bench. Had you been in Odisha, the problem would have been otherwise. Today, you chose the forum of Kolkata.
Your Lordship, I have not chosen the forum. That is what I want to submit before Your Lordship. I have challenged, but since the AFT bench for entire Bihar, West Bengal, Jharkhand, Odisha is at Kolkata bench, so I am duty bound to do that. I don't have any other choice, Your Lordship.
Very good.
So since I don't have any other choice, so I am there. But I have the Honorable High Court at Odisha as well.
Now, has it been constituted, Odisha Tribunal? Now in Odisha, there is any administration?
No. AFT is collective.
Your contention is that although the employee has retired, who is a man of Odisha,
Original
he was required to prepare an original application in Odisha, but there is no tribunal in
Odisha.
And hence, as per this notification, he has filed in Calcutta.
Calcutta bench.
But since a man of Odisha, the order of Calcutta bench is to be challenged before Odisha High Court or the Court of High Court.
Yes, it is.
Your content.
Yes, Your Lordship. That is my humble.
What is the main matter about?
May I submit, my lord? Kindly see the impugned order, page 2. Impugned order.
Is it
After
different
102.
is it different from the matter?
No, similar, in complete parallel case, my lord. He was not discharged on the ground of medical leave. He was discharged after the completion of the full terms, my lord. Terms of service, my lord. I am relying also Supreme Court judgment 2022. Your lordship referred that judgment. Kindly see, my lord.
Your Lordship, AFT after.
Let me submit.
No. You are misleading the court. Your Lordship, Honorable AFT bench, after considering all the judgments, Honorable AFT bench, after considering all the judgments, has passed in favor of me because I am the sufferer. After serving so many years, now I have applied, I approached the Honorable AFT, and once the judgment has been passed, now they have come up with the.
With you argue on merits. He's praying for an interim order. He's praying for an interim order. We have to consider his prayer. If you say you are not ready to argue on that point, that is a different issue. Maintainability, prima facie, we do not find that there is any maintainability problem here. If you say that you want to argue on the merits as regards the interim order, then you are free to do so.
So, beseech before Your Lordship, kindly fix one more date to 5.
My lord, may I read Your Lordship passed the order? Kindly see page 94.
Hard Mr. Singh, Mr. Learned Advocate appearing for the petitioners. No. Appearing for the petitioners. Mr. Singh, Learned Advocate appearing for the sole respondent. Raised for an accommodation to avail necessary instruction. Please the matter for further consideration in the daily supplementary list of this court on 26th. 27th we are
obliged.
Please take back this copy. Give a Xerox copy to him. Give it back.
I am
grateful.
grateful.
On 26th and
obliged.
Both are similar matters. You are appearing in the
other. All are similar. Complete parallel case, my no. Similar matter, my lord.
No. There are two matters.
No, my lord. Only one matter.
I am appearing for one.
Under the same heading. Motion ही डाल.
They are all the respondents.
I am the petitioner in person for item number 10.
You have two matters. You have two matters.
Yes, two matters.
Next matter is also here.
Yes, yes.
Yes, tell us. What is
I am Assistant Professor of Government College of Engineering and Ceramics.
Just give us 2 minutes. Let us go.
17 January 2024 improving order.
17 January.
January.
That is the order in place.
Yes.
Which order did you challenge before the tribunal? The order was passed rejecting your prayer for grant of leave.
Yes, yes.
Where is that order was challenged before the tribunal?
At present, there is no judge in the administrative tribunal, only administrative person.
One of the page 24, one of can I see?
Page 24.
Oh, yes. Order dated 1st February 2023.
That's
Which was reason order passed by the authority in terms of the order of the tribunal.
earlier also he have.
Ordering portion at page 25.
When are you retiring?
Next year.
Next year.
Next year, April.
So what is the interim order scope? There is no scope for you are working now.
Yes, I am working now.
Your prayer for regularization of 548 days have been rejected.
Unauthorized absence.
Please check page number 56.
56.
56. Para 6. Para 6.
Para 6.
In the second line, they have said, I say that applicant has claimed that he had applied for leave without pay for his M.Tech study, but no record of leave has been found in the office of the college. Respondent have no leave of record. And again, they are telling that unauthorized absence. On the basis of my statement, as a faithful employee, I told that I was absent for conducting for the completion of my M.Tech course. And on the basis of my statement, they are telling that unauthorized absence. But they don't have any record. And in the next case, they have stated service book of the employee could not be found in the office.
What is the next case about?
No, next case means this is WP 38 in the WP 39.
What did you challenge in 39?
Past service continuity of past service. Because I worked at Kolani Government Engineering College 10 years. And I submitted application for the post of lecturer. At present, I am working as an assistant professor. But in the Kolani Government Engineering College, I was working as a laboratory assistant. But as a laboratory assistant, I submitted application through proper channel. That is next case. But in this case,
that is regularization, that is counting of your past services.
Yes.
Here it is rejection of your prayer for grant of leave.
Yes. But the respondent have stated that in the page number 26, please check. Page number 26, please see. In the last but one line, hence, in the absence of any specific provision in the WBSR, the regularization of the period of absence is not permissible.
Yes.
But I have already given the example of sanction of leave. There are so many examples of sanction of leave. Here I have given 2 pages, 22 and 23 of West Bengal government. Page number 22 and 23.
So your pleadings are already on record. You have annexed the reply rejoinder filed in this matter.
Yes, yes. No,
then we will...
previously, in a reply, they have stated no leave record.
Kindly see the impugn order first. Kindly see the impugn order.
Mr. Mukherjee, it has to be decided finally. There is no scope for any.
Yeah, there is no scope for interim order.
And my request, please check page number 919. Kolani Government Engineering College told me to join, and my absence period will be regulated as per rules. But they have not taken any initiative. Otherwise, I would not join there. I would join in the private colleges and anywhere. Please check page number 19.
Have you served the college?
That is
yes.
in 2000. That is in 2004. That is in 2004. And his unauthorized absence is
in the second para. Please see. In this regard, I am directed to.
There is no scope for any interim order. This matter has to be finally heard.
But my matter was not heard there. Again and again, I told that I had been told that your all service matters will be regulated as per prevailing rules.
Yes, that would be decided finally. But today, is there any scope for passing interim order?
No, I don't want any interim order. In the next case, I want interim order. In the next case, in the WPST 39. In the next case, just I want interim order.
He is unauthorized absent from 6 January 2003 to 31st
July
July
2003. The next matter also.
I do not know what.
Another matter, in a letter, I had been told to join. In a letter dated 15 June 2004, I had been told to join within 7 days. After receiving the letter, I joined at Kolani Government Engineering College. Page number 16. Page number 16. I had been told to join within 7 days. I joined and signed in the attendance register after discussion with the registrar of the college. Then principal was not present. And I also gave undertaking that I would confirm my duty regularly. Then principal came and imposed so many conditions. And when I was not agreed, I had been instructed to leave the college.
Can you see the rule 175?
Are you there in the next matter?
Just my learned junior is there, but certainly I will appear.
In the page number 16, they told to join. Page number 16, annexure page.
But kindly see the order in the next matter.
Page number, in response to the instruction of the principal, I informed this matter to the Director of Technical Education, and letter is here annexure page 17 and 18. So I am not responsible for the period of absence.
The next matter, unauthorized absence to be regularized, and he has to be given to the career advancement scheme. That is not permissible.
What interim order do you want in the next matter? You have challenged the same
No,
order.
interim order means after completion of my MTech course, again I joined there and I worked for about 16 months service. And that period is beyond any dispute. So that period must be counted immediately for the past service.
You are now working where? You are
Then I was at Kolani Government College.
Presently, where are you working?
At Government College of Engineering and Ceramic Technology.
Very good. By the order, your prayer for regularization of the period during which you pursued the course was rejected. And that period shall not be counted towards your service tenure. That is the order passed.
Yes.
So what interim order you want? We have to hear
But
the
that
matter
was
finally.
10 years service. So my early, my group insurance money, I will not get anything.
That you can only get provided you succeed in the main matter. Unless this matter is finally heard, how can you get the final relief? What interim order you are praying?
Interim order in the next case, I have prayed that I joined after completion of
proceedings. You have started any disciplinary proceeding?
The government has decided to take any actions against, but because of the order, his unauthorized substance could not be regularized. He has been issued a show cause notice, but till now we have not taken any.
Show cause notice issued when?
Long back.
Which culminated in the order of 1st December.
Yes.
Oh.
I got show cause notice, but I joined. I joined and signed in the register. And principal instructed me to leave the college. And being a subordinate staff, I had to compile with the instruction of the principal.
Kindly see page 23 on the second matter, page 23 in the second matter. Here prayer is to authorize period of absence to be regularized and it should be get benefit of career advancement scheme. That is not permissible under Rule 175.
If this is unauthorized absence, tomorrow you will issue a charge sheet against him.
If he charge sheet issued, he can challenge that.
No.
Don't
take coercive steps.
Comment? You will proceed on the basis of that charge sheet.
No, till that charge sheet has not been issued. Premature. Premature. Till that charge sheet has not been issued.
That is why we will say.
No, during that period, government
there is no scope for stay. There is no scope for stay.
We are passing an order. Don't take any coercive steps against him. Otherwise, Mr. Mukherjee.
Coercive steps. Kindly see.
No, government cannot take advantage of its own delay.
Kindly see. Unauthorized absence has not been regularized because of Rule 175.
That we will consider.
Rule 175 has not been challenged. Number one, rule has not been challenged. Tribunal directed he considered his case.
Wait, Mr. Let us hear.
In the second case, in the page 55, 58, they have told service book of the applicant could not be found in the office of the state college.
Wait.
Can you see first matter, page 25 for a moment?
Yes, wait.
Point for consideration. Now the point consideration is whether or not the applicant is entitled to extraordinary leave without pay under Rule 175(2) Roman 3 of the West Bengal Service Rule Part 1. The extraordinary leave of government employees governed under the West Bengal Service Rules Part 1, Rule 175(2)(a) provides that except in case of government employee in permanent employment, no government employee shall be granted extraordinary leave on any occasion in excess of 3 months. Rule 175(2)(b) Roman 3 provides that the extraordinary leave for 24 months may be granted where the leave is required for the purpose of prosecuting studies certified to be in the public interest. provided the government employee concerned has completed 3 years continuous service on the date of expiry of the leave of the kind due and admissible under the rules, including months extraordinary leave under clause 1A of rule sub-rule 2. In this instant case, the initial appointment of the applicant for the post of laboratory assistant in electronics and communication engineering department was on contractual basis for a 1 year and joined on 6 September 96. And his appointment was confirmed on 7 July 99. Thereafter, he joined in the post of technical assistant contractual basis on 6 January 2001 in the same department by taking lien for the post of laboratory assistant. The letter of the Director of Technical Education dated 16 May 1, the prayer of the applicant for release of lien was allowed in order to enable the applicant to join in the new post of technical assistant for a period of 1 year on contract basis. Contract basis. Applicant applied for leave on 24th February 2002 and continued MTech study from August 22 without having obtaining permission, any leave, and remain absent from 6 January 2003 and thereafter returned to the post of laboratory attendant on 1st August 2003. Applicant remained absent from 6 January 2003 to 31st July 2003, 207 days for the purpose of attending theory classes of MTech and thereafter on 28 January 2004 to 22nd January 2005 for attending practical classes, that too without having leave granted for the health. The absence of specific provisions in the West Bengal service rule regularization for the period of absence is not permissible. Can you see?
And what is the next petition? Next petition also challenging?
Next petition, first regularization of service and career advancement scheme.
The quantity of past service, not regulation of.
But until unless he has a
Where is that rejected? Your continuation of past service?
Page 23 and the second matter. Page 23 of the second matter.
Hey, two different orders were passed?
Yeah, different orders. It is for career advancement schemes.
And also order was incomplete in respect of its implementation. Only that is written that 548 days cannot be counted. I submitted application
Mr. Mukherjee,
through proper channel.
2000. সেটা তো ফার্স্ট
I submitted application through proper channel in the page number 27 annexure.
No charge sheet has been issued, no decision has been taken to initiate the proceedings. If he initiated, it will be the fresh cause of.
You will issue. Why did you allow him to join in 2005, Mr. Mukherjee?
Can you consider if somebody applied for leave, certainly government has power to grant leave.
Please answer our question. 2000, his period of leave was for two spells, 548 days,
yes.
Of which year? It is of 2003. He was allowed to join again in 2005. Now, after 15 years, you are passing this order.
No. When he approached this...
Forget about his approach.
No. When he approached the department.
This order was passed in 2023, Mr.
Yes. When this tribunal directed us to consider this regularization of his service, we have considered it.
Yes. But what do you do prior to that? You did not take any coercive steps.
We could have terminated this service, but we have not terminated this service.
It was better. Then I would join in the private colleges.
In 2003, he was allowed to join.
Yes.
He has continued the service. His application for regularization was kept pending. That is why in 2022, he filed a fresh application. Court said that you consider.
Yes.
Now you have considered and rejected his prayer. But when you have allowed him...
Is there any prima facie case that we have committed?
But prima facie case is this. We will hear the matter, but in the meantime, you will not take any coercive steps against him.
But coercive steps, what are that?
In the backdrop of the fact that you did not take such steps for a long period from 2003 to 2020.
But I can't see. Tomorrow he will go, give me the career advancement scheme.
Huh?
So
will you give it to him?
No, that's why the contempt application filed before all, we have no coercive steps.
Contempt about what?
What we have rejected his prayer for career development scheme.
Yes, what more order you will pass? We are not interfering with that order. Are we interfering with?
No.
I submitted so many applications, but I did not get any response until I approached to the Honorable Administrative Tribunal. 15 years they are aloof.
Analogous hearing
in a vital matter. But in the second case, please use an interim order.
They are passing an interim order.
Okay, thank you.
Common question of law and fact. Would the repetition be hard and unoffensive? Petitioner joined as a laboratory assistant
Kolani Government Engineering.
Kolani Government College of Engineering.
Government College of Engineering and Ceramic Technology.
And Ceramic Technology.
Government College of Engineering and Ceramic Technology.
This is the new name. You have implemented them as
in 1996 as laboratory assistant.
Ceramic name. Kolani Government Engineering College.
Kolani Government Engineering.
Where do you get ceramic?
Ceramic at Belaghata.
You are working where?
At Government College of Engineering and Ceramic Technology from 1st June. From 2nd June 2006, I have been working at Government College of Engineering and Ceramic Technology.
There is no such response.
Now,
subsequently,
it is your best appointment or in continuation of the same?
No, it was fresh appointment.
No, 2006.
Yes, it was fresh appointment. Initially, advertisement was published for the 1-year service, and I applied to.
When you leave your service in earlier post,
yes, that is related to Kolani.
Paid all the benefit accrued towards for the past service.
For past service only. In this service, there is no dispute. In the present service of Government College of Engineering and Ceramic Technology.
Ceramic Technology is not a party. You have not.
No, it is not a party because I have not made them party. No. Here is no problem. I want the past service of Kolani Government Engineering College only.
Ceramic Technology College at Beliagata, that was made party.
They have no relation in this case. And there is no dispute.
So now you have left the job. You have joined in the Ceramic College as lecturer.
In 2006.
Government College of Engineering and Ceramic Technology.
It's a fresh appointment.
Fresh appointment.
Having no connection with your past service.
But I applied through proper channel. That's why I wanted that my service should be counted past service. Since at Kolani Government College, I submitted application through proper channel.
So even if now the Kolani College, authority of Kolani College hold you that you are remaining unauthorized absent, even if they, on the basis of that, they issued, initiate a proceedings, it will not touch you at the present.
Yes.
For your service.
No.
So no interim order is required.
No interim order required to pass.
Because after the completion of my MTech course, since I applied through proper channel, so I claim the first service with this present post of with this present service.
Now we are finding whether there is any scope of passing any interim order or not. You have stated that in first matter your prayer for regulation of your period of absence was turned down, and in another matter you have been held that you are in unauthorized absence. We are under the impression that on the basis of such observation, that you are under the unauthorized absence, they can initiate proceedings against you. But now they will not be able to initiate any proceedings against you.
But the period. But after the period of unauthorized absence, then I joined there. And their service period must be counted from 2005. 3rd January, I joined there 3rd January 2005 in response to the letter 21st December 2004. In that letter, they told your service matters will be regulated as per rules. Please check page number 19.
1996, and the said appointment was confirmed.
Please check page number 19.
1999. In 2002, he made an application seeking study leave
without pay
to pursue MTech. To pursue MTech, but no decision on the was taken on his application seeking such study leave. Despite the petitioner pursue the MTech and remain absent for almost 548 days.
Subsequently, became the post of assistant professor. তুমি লিখে দাও পরে 548 days.
548 days. Stop.
Your Honor, but I am not responsible for the period of absence.
Hey, wait. After completion of further, after completion of that course, he was allowed to join in government college, in Kolnani Government College. Allowed to join in government.
When were you allowed to join?
In the, please check page number 19.
Page number 19.
Annexure page of the first case.
In 2005. In 2005. That is on 3rd January
2005, I joined. In response,
when did you join the ceramic technology?
No, at Kolani Government in ceramic technology, 2nd June 2006.
Thereafter, he joined the.
Thereafter, he joined
the post of assistant.
Post of lecturer. Post of assistant professor of
lecturer. First, you were appointed as a lecturer on contract basis.
Contract basis.
In the ceramic college.
No.
Thereafter, you were confirmed as, thereafter you were appointed as the assistant professor.
The designation was renamed as assistant professor.
Oh, designation was renamed. But your joining in the post of lecturer was in ceramic.
Then in 2006, he joined as a post of lecturer, joined as a lecturer in Computer Science and Engineering Department of Government College of Engineering and Ceramic Technology. Subsequently, by making an application, one application you make, or two applications.
Two original applications were filed.
The petitioner approach the authority concerned with a prayer for regularization of his period of absence and counting of that period for counting of his past service for extending CAS benefit. CAS benefit. Stop. But despite receipt of such application, the same was left unattended, and hence the petitioner approached the tribunal seeking a direction of the concerned
Which was disposed
to consider
approach the tribunal by an original application.
Approach this tribunal by preparing an original
Two
application.
applications. Two earlier also you filed two applications.
Two applications.
Earlier.
Earlier also two original applications.
Yes.
When it was directed.
Yes, two applications.
By filing two original applications.
Way 26 and way 27.
Which are disposed of by directing.
Earlier, when you, on the basis of which this order was passed, OA 26, you challenged the order of 1st February 2023.
Yes,
earlier when the direction was there on 21st of September 2022.
Yes. That is way number 26 of
way number 26. And then way number 467.
Which by filing two original applications being OA number 26 of 2022 and OA number 28 of 2022. Which are disposed of by directing the concerned respondent to decide the issue raised by the petition.
In the light of the existing rules and
regulations. In the light of the existing rules and regulations. Stop. In compliance with the order passed by the learned tribunal, two different orders, both dated 1st February 2022 was passed, whereby the pair for regulation of the bill were both the pair of the petitioner were negated. So, agreed thereby, the petitioner again approached the tribunal by preparing two separate original applications.
467 and 468.
Dismissed.
467 of 2023 and 468 of 2023. And the order and by passing
an order dated 17th January 2020.
And by passing to different order, both dated 17th January 2024, both the original application were dismissed. Stop. Against the order of dismissal, two different petition has been filed with WP number.
WPST number 38 of 24 and 39 of 2024.
And 38 of 2020.
And as such, with the consent of the parties, both are taken up for hearing and appeals.
As such, with the consent of the parties, both are taken up for analogous hearing with the consent of the parties. Stop. Having heard the submission, having regard to the submission made on behalf of the respective parties and upon perusal of the materials on record placed before us, because we have of the view that the petitioner has made out a good arguable case, and if during the pendency of this petition, the interim order as sought for by the petitioner is not granted, the petitioner will be highly prejudiced. In the circumstances, there shall be an interim order restraining the respondent to take any steps, any coercive step
against the petitioner
on the basis of the observation made in the order impugned,
orders
impugned, holding him as unauthorized absent. Stop. We are of the view that the issue raised in this petitions are required to be decided upon exchange of the affidavit.
Some affidavits were filed, no? Before the tribunal, affidavits were filed.
No.
Not filed.
Not filed.
Affidavit of service.
No. Reply.
Reply rejoinder. Have you annexed?
Yes,
With the petition?
yes, I said, I submitted reply. Rejoinder, I submitted rejoinder.
No, that can be not annexed. Only OA has been filed.
Till the
Only Bimal Pal.
Rejoinder is
Till
given.
the end
No,
of the
rejoinder is not there.
before or until further orders, whichever is earlier, stop. The respondents are directed to
This
file
is
their
rejoinder.
affidavit in opposition.
No, reply.
Affidavit in
Reply was
opposition.
rejoinder also.
4 weeks.
Reply and rejoinder both are here in the petition.
Both are here.
Yes.
You want to file any further affidavit, Mr.
On the basis of the pleading.
Till the end of the we have been informed that the pleadings have already been annexed to the respective petitions. In view thereof, list the matters for final hearing under the same heading in the combined monthly list of May 2024.
May
2024 in combined monthly list you will appear.
Under the same heading.
Under the same heading.
And we have restrained them from taking any coercive step against you on the basis of the observations made. You will get the order in the server.
Okay.
We have restrained them from taking any coercive step against you. Understood?
Okay. But they should have taken during that period. If any action they wanted to take, it should have been taken during that period.
If you are in unauthorized absence, they cannot take step against you today. Then we vacate the interim order. When you are so confident, we are vacating that order. What do you say? Yes, next.
I'm the state inspector.
ওই উপরে এভিডেভিট অফ সার্ভিসটা রেখে দিতে
মানে affidavit of service, my lord, second judge is copying, honorable second judge copying, not in proper paper, my lord. So that, my lord, not in bond. Xerox, sir. Here,
compassionate appointment.
Yes, my lord. My lord, petitioner father, my lord, page 38 first, my lord. Order of the tribunal, my lord.
When did your father expire?
Yes.
When did your father expire?
Father expired, my lord,
2016.
2016.
23rd September.
Your reply rejoinder is here.
Yes,
Whether
all my lord.
considered or not.
Reply rejoinder all is
Yes.
there. All.
And in his Milord, in his one page 28, Milord, Lordship will find, Milord, his own admission, page 28, Milord, kindly takes the
Been recorded in the
order, Milord. That 21 years, but authority was reluctant to regularize the service of his father in his service.
My lord,
It will be hard.
only points involved, my lord, whether a person under company appointment, and in permanent nature, regular is necessary or not. When my Supreme Court, and my lord, all my lord, High Courts, my lord, come into conclusion, my lord, that dining in harness character is compulsory appointment or is permanent nature, not my lord temporary nature.
We kept on record. Upon hearing the learned advocates appearing for the respective parties, and upon considering the materials on record, we are of the opinion that there is no scope towards issuance of any interim order. Stop. When did he die?
Die, my lord?
In 2016, but in
23rd September.
my lord, 23rd September, the pleadings, but a letter, my lord, which has been annexed, my lord, in this writ petition, wherein it has been mentioned that the father died in 2021. I just showed to his lordship that letter. I just know.
There is no scope towards issuance of any entry order. Stop. We have been informed that all the pleadings exchanged by the parties before the learned tribunal has been annexed. All the pleadings had been annexed to the present writ petition. In view thereof, list the matter for final hearing in the combined monthly list of May 2025. Yes, next.
Father died on 23rd September 2016.
Nah, in page 63, my lord, mentioned that Amar Pita gato 23/9/2021 তারিখে পরলোক
All right, we have admitted your application.
Yes, ma'am.
Yes.
May 2020. Monthly list. That will get. Okay. Get one.
Yes.
It's my application, my lord, for compassionate appointment.
Commissioner. Compassionate appointment.
Our petitioner's predecessor was a Resham Kormi, my lord, ex-Resham Kormi. My lord, he died, my lord, in the year, my lord, 2012, my lord. An application was made, my lord. Thereafter, my lord, it was not taken up for consideration, my lord. And application was made before the tribunal, my lord. Tribunal by an order dated July 26, 2016, my lord.
Similar. Resham Kormi, regularized.
He was not a permanent employee.
Same order. Yes. A reply rejoinder you have annexed.
Yes.
Reply rejoinder you have
Everything has been annexed. What are matters of record has been annexed.
No. Reply rejoinder.
There is no reply rejoinder.
There was no reply rejoinder. Then Mr. Mukherjee used an opposition. There is no. Upon aware of the there is no scope towards issuance of any interim order. তারপরে লেখো the respondents are directed to file their affidavit in opposition to the writ petition within 3 weeks. Reply thereto, if any, be filed within 2 weeks thereafter. List the matter for final hearing in the combined monthly list of May 20. Yes. Next. Item 14.
My lord, item 14, I am for the petitioner, my lord. In this matter,
is suspension matter?
No,
my lord, termination. My lord, in this matter, what has happened? The petitioner has also preferred a writ petition questioning an order of West Bengal Information Commission. And my lord, in that matter, my lord, Mr. Chakraborty has been engaged. So, my lord,
on personal ground of one.
And my lord, may I also point out that this original application, along with a similar application, was heard analogously and disposed of by a common, not by a common order, on the same mode. No, the honorable tribunal. So, my lord, there may be another application. So, I leave it to your lordship as your lordship pleases. আরেকটা মানে একজন একই order.
Very good. When you file that matter, you have filed that matter.
No, I am not in that matter.
Who has filed?
My lord, Mr. Siddhartha Banerjee was there in the tribunal. So I do not know whether Mr. Banerjee has been, learned advocate has been engaged or not by the.
No, you have been engaged. This is against tribunal order.
This is against tribunal order.
So there are two separate tribunal applications.
Yes, by a single termination order, 2 persons were terminated. I am representing, another one was being represented by Mr. Siddhartha Banerjee. And so, my lord, I have filed a WPST, my lord. Mr. Banerjee.
Ask Mr. Banerjee to mention that before
my lord, I will not
on personal ground of one of us, bole amar naam diye dilo. The matter stands released from our list. Let the matter be placed before the Honorable the Chief Justice for assignment before the appropriate order. ওই মুখার্জি সাহেব এজিপি বোল্ড করে লিখে দেব। Yes, Mr. Mukherjee, we have said it should be in bold letters.
Well, may I file the affidavit, sir?
আর কি হবে?
My lord is bold in all respects. My lord is bold in all respects in our mind.
ছুটির আগে এত
Your
Why
name
you are
would be written in bold. Your name.
Why you are
I got the privilege to take some assistance from my lord Justice Chakraborty in the corridor when he was in the bar. And I have learned something when code number 17 and code number 1. And still we are learning from this court also.
Yes. Yes, next. Item number
15, my lord. I'm for the petitioner. I'm led by Mr. Shoktinath Mukherjee, my lord, on virtual mode. Kindly permit him to address.
May it please the lordship. May it please the lordship.
Yes.
I beg to appear, my lord, on behalf of the appellant. Is against the order of the tribunal to refuse to grant an interim order. I am pressing this application for an interim order on these facts. The fate of about 300 flat owners are involved. Kindly turn to my list of dates. Kindly turn to refusal to grant an interim order. I am moving this against the refusal to grant an interim order, and I am praying for an identity stay in the event I am able to satisfy your lordship.
And who is for the state?
Milord, I beg to appear for the state.
Yes, Mr. Mukherjee.
Kindly turn to my list of dates.
List of dates.
Mr. Banerjee.
It's okay. Evidence service. Finding the affidavit of service and a list of dates.
Kindly have a look at the list of dates, my lord. It's a matter, my lord. Which, my lord.
Order 2 minutes, we shall come back.
Mr. Banerjee, kindly keep the Mr. Justice Tandon's judgment ready.
Yes, yes.
Where is this order of December 2022 which you challenged?
My lord.
Yes.
It's being placed before lordship. 5th December 2023. One line order, no reason order, because the government has opposed it.
36.
Just show it.
Yes, Mr. Mukherjee.
I filed an application with a prayer for interim order. The tribunal, because the government was opposing it, declined to pass an interim order. And I have moved your lordship against that refusal on the ground that a grave injustice is being committed. Kindly turn to my list of dates.
Yes.
Not the one annexed to the petition. There is a separate list of dates. Mr. Banerjee will hand it over to Lordship. Mr. Banerjee, yours.
Handed over.
My Lord, the first item, your Lordship will find, my Lord, two dark numbers are our dark numbers, and they have been recorded in the record of rights at Dokalkar. Can you mark it?
Yes.
Kindly turn to the petition, page 43. Petition, page 43.
Future prayer.
I'm just finding out the ROR, my Lord. Record of rights.
We could have written to page 48.
I'm sorry, page
48.
48, my Lord. Kindly turn to page 48.
Page 40?
No. 48. 48 to
Page 43.
No, ROR. No. ROR is page 68.
68.
67, 68.
No. Arrest out है. 63. Kindly turn to page 63.
63.
63. Starts from 63.
63.
Yes.
Dokolkar.
Dokolikar.
Yes. Kindly keep it in mind, my Lord, until the disposal of the matter. The matter will take some time. There are two Katyans. One is 63, another is 65. 63, kindly turn to page 63. Dokalkar. Page 63, Dakalkar, and at page 68, 65, Dakalkar. What does it mean? Dakalkar in the record of rights. Dakalkar means, kindly, my Lord, keep in mind, this is not a matter which is coming up to your Lordship in usual course. Dakalkar is a technical term in the settlement department. It means a non-agricultural tenant. Dakalkar means a non-agricultural tenant. My Lord, for that purpose, kindly turn the judgment of Justice Bijoy Mukherjee, reported in 70 Calcutta Weekly Notes. 10.
We will come to the judgments. You tell us what interim order.
This is a crucial point. Dakolkar means a non-agricultural tenant. Now, kindly turn to the State Acquisition Act. Kindly pick up an State Acquisition. I'm just going straight to the point.
The citation 70 CW.
70 CW and 1079.
1079.
State Acquisition Act.
Hey, Mr. Banerjee,
Yes.
don't you have a extra copy of State Acquisition Act?
Yes.
Kindly turn, my Lord, to section 2I.
Sir, just one.
1079. Dokolkar means agriculture, non-agriculture.
I'm coming. Keep that judgment ready.
Yes.
Section 2I, my Lord.
Yes.
What intermediary means? The definition of intermediary in section 2I. Has the Lordship got I, my Lord? Clause I of section 2. Kirib.
Yes.
Of course.
2I, definition of intermediary.
Yes. Means a proprietor, tenure holder, under tenure holder, or any other intermediary above a right or a non-agricultural tenant. Therefore, an intermediary is somebody above a non-agricultural.
Yes.
Be satisfied about it. Be satisfied about it. A non-agricultural tenant is not an intermediary. Above a non-agricultural tenant.
Above a non-agriculture tenant or riot.
Or riot. Therefore, non-agricultural tenant is not an intermediary. Kindly turn to section 4.
Yes.
Below, kindly section 4.1. notification bringing about vesting of estates and interest of intermediaries therein. Be satisfied about it. Section 4 provides for the issuance of a notification. For what purpose? For bringing about the vesting of estates and rights of intermediaries therein. Be satisfied about it, Lord. Therefore, non-agricultural tenants are not within the definition of intermediaries. Notification is issued in respect of estates and intermediaries' interests. Now, this question was considered by the Supreme Court in 1967 Supreme Court, 620. Where is the book? Hand over to my lords.
Supreme Court?
67 বইতে জয়সেব দেওয়ার জন্য বলছি প্যারাগ্রাফ 9
Of which judgment? Paragraph 9 of?
67 Supreme Court.
He is referring to the next judge. মনোপত্রটা এনেছে মনোপত্র তো হবে না মিলবে না প্যারাগ্রাফ 9টা দেখি একবার but kindly give me এটা কি না না অন্য কিছু judge. This is not the judgment. 67 টা আনা না নেই এটা this is not 67.
নেই না না ওখানে জয়সেবের কাছে আছে May I read out 67 কোথায়
আসেনি
আসেনি
Lord, may I read out one paragraph, Lord?
Yes. What happened on 6th of March 2024?
They didn't file
affidavit. They did not file. The state did not file an affidavit against Lord Supreme Order.
I'm telling your Lordship.
I'll just read slightly marked.
কি ওটা
6th March এ কি what happened on 6th March?
My Lord,
Yes.
Milord, your Lordship need not worry about it, Milord. Supreme Court in 67 Supreme Court has held non-agricultural tenancies are not affected by the State Acquisition Act. Kindly remember it. Non-agricultural 67 Supreme Court 940.
Yes.
Paragraph 9. Non-agricultural tenancies are not affected. We don't need. Not affected. They are not governed by the State Acquisition Act. And relying upon that definition of 2I.
Agricultural tenants are excluded under the Estate Acquisition Act.
Yes.
No, in my case, I am a non-agricultural tenant recorded. I am not affected with the Estate Acquisition Act. I will not apply for de-recognition of my premises. I am reading out. I applied for recording of the fact that my premises are no longer used for factory purpose. It ceased to be used as a factory purpose from 1980. In the LR record of right, my property has been recorded as Vastu.
Sir,
but
this fact is repeated at page 70. If your Lordship looks at 70. This fact, which Mr. Mukherjee is saying, the authorities have accepted this at page 70. 70. Your Honor.
Kindly turn to 70.
My lords will find at page 20 this fact is accurate.
This is official. Then time to the next page. Next page. Government is said not affected by 6.3. I'll take your lordship to 6. Next page.
Clear on that, Mr. Mukherjee.
This is the government version. District Land and Land Reforms Officer. Communicating this is not affected by 6.3. A particular person may not move the writ application in this honorable. They are making illegal construction. This honorable court directed them to and the authorities to consider the allegation. The authorities have communicated now, my lord, at page 71.
Yes, which
I'm
page?
sorry, 196.
196. Yes.
This is the matter under challenge. Six three, I'm affected by 6.3. Is it, your lordship has got it, my lordship? I'm affected by 6.3. And the municipality has issued a consequential order, stop all over. I have completed 300 flats. Most of them are occupied by families. And there are other flats below under my 563 is there, and I have misrepresented. Your lordship is reading 6.3.
Yes.
Kindly read from paragraph section 4, 5, and 6. I beg to assist your lordship.
Last two lines of this letter may kindly be read.
Yes.
Page 71, last two lines.
Same thing, page 71.
When did you file this proposal for regularization of post facto?
My lord, this is after completion of the building on a plot of land which is recorded as bus 2.
That is page 129 to 132.
129 to 130.
Yes.
Without prejudice বললাম যে
No, when did the building come up?
Earlier on the basis of the LR record. LR record says bus 2.
Lord, the sanction was obtained on the basis of, Lord, the record of right. And Lord, this sanction came on the, kindly give me, Lord, 1 minute.
Sanction fee 6/10/2018.
6th of October 2018. 6th of December, yes, to 6th of October 2018, the sanction was granted.
6th of October
2018.
That is page 119.
19, page 190.
2019 extended.
Yeah, just
item 8.
On the basis of your LR note.
Yes.
This is by municipal corporation.
Yes. Because Lord,
record of rights. LR record has now recorded as bus 2.
On the basis of your LR record.
Yes.
Now the building is over.
No, it is still under construction because Lord,
what happened?
We sought Lord extension. Your lordships will find at page 120.
Yes.
This was extended. Then Lord, Howrah Municipal Corporation issued Lord a stop work Your Lordships will kindly, Lord, see page 128.
128.
This is where the trouble started. 120.
Now thereafter you made the application for post facto
Yes,
conversion.
That was without prejudice.
This was then, Lord, we filed this application. Kindly see page 129.
Very good. Then on the basis of this order was passed in 5th of December 2022.
Yes.
Kindly read that. Kindly read that order once more.
Mr. Banerjee, please place the order. It is a bit unclear.
136. It's in 2 pages. 136 is also there. Kindly see, Lord, that is, Lord, that is legible.
Yes.
May I place 136, Lord?
So this proposal for regularization was given by you on page 129.
Yes.
That is on 12th of May 2020.
Yes. Correct.
Now this proposal was considered and was turned down.
Yes. This
Cannot be granted because of 3.6.
It is
Cannot
not
be granted because of 6.3.
Yes. What it says
It
that
cannot
it
be granted in respect
because of section 6.3 and
6.3
then
doesn't apply.
to start proceedings for illegal conversion.
अरे सुप्रीम कोर्ट ने नहीं
হ্যাঁ আজ আজ আনতে দিয়েছে স্যার, আনতে দিয়েছে, উনি আনেননি সঙ্গে, আনতে দিয়েছে।
Lord, question is whether 6.3 would be applicable in respect of a non-agricultural land, which is
tenancy,
non-agricultural tenancy, which is held not within the ceiling limit.
May I hand up to your lordship a very recent division bench judgment? Did Cannon Shabbat judgment. A very recent, considering 4 other division benches.
This was in 2022.
Yes.
So why did you wait for 2 years?
We did not, Lord. We filed the OA.
Filed the OA on sometimes in 2023.
Of the municipality.
Lord, in between.
2024, in fact. You waited for 2 years, Mr. Ford?
No.
Yes. 5th of December 2022 was the order impugned.
No. Kindly, Lord, in between, there is a public interest litigation file on 29th August 2022. Your Lordships will find that in serial number 15.
That is still pending.
That is still pending.
Serial number 15.
50 of the list of dates. And Lord, there is, Lord, a writ petition that we filed challenging the stop work notice in so far as the Howrah Municipal Corporation is concerned.
Then what happened in
That
that?
there, your Lordships will find page 145. It is sent back to the Commissioner.
This was also in March 2023.
Yes, but Lord, when it is sent back to the Commissioner, then we realize, then Lord, there is an appeal preferred against that. That is pending. And in the meantime, Lord,
appeal preferred against
this
order.
Yes, which is pending. And Lord, in the meantime, we also realize that Lord, we will have to get over this
6.3
this 5th of December. 5th of December.
That it is a 6.3 land.
Unless that is sorted out, HNC will
unless that is sorted out, Lord, our representation, which has been directed to be considered by the Commissioner, will reach a dead end.
So, but the appeal is pending against that order.
That appeal is pending, but not in the meantime.
Did you get any interim protection there?
Interim protection. No, that appeal is pending.
So this
My
issue
lord,
by them.
my lord,
But
Prejudice
immediate prejudice is that initiation of proceedings which has been directed in this letter of 5th of December, page 136.
2022.
Right.
We are 2 years thereafter.
That they have not initiated as yet. Then Lord, the whole thing, my whole project gets upset.
400 flats.
Exactly.
My lord, bear with me for it. My
Lord,
lord,
interim order has been refused only on the ground that it will be considered after the affidavit of Lord the state is filed. Lord, unheard of. Lord, I am entitled to a prayer. I can understand my prayer is rejected. The tribunal, kindly see the order of 5th of December. Tribunal is saying that I will consider only after the state files the affidavit. It is conditional upon Lord the state's filing affidavit, and next day, Lord, your Lordship has seen state has not filed the affidavit. So, Lord, again another date.
my lord, this old man has a submission to make before lordship.
Yes.
6.3 is not applicable to non-agricultural tenancy, nothing else.
Understood, Mr. Mukherjee. That was
Then what is to be done here? 4 division bench judgments are there. I'm placing before lordship, one after another. Estate Acquisition Act doesn't apply. Therefore, 60 doesn't apply.
Commissioner was not aware of the consequences for 2 years. You tried.
No. We are facing different proceedings with the High Court.
That in December 2022.
My lord, they were not implemented.
Expressing Mr. Mukherjee was there in 2022. Why should
My lord, even then, if the act is not applicable, I'll be proceeding against that act.
To be decided by the
It's a nullity, my lord. That order itself is a nullity.
This is you are approaching different forums, failing to.
I am not approaching. They have approached. Kindly, my lord, have a look at the division bench, recent division bench. Section 6.3 doesn't apply. Kindly have a look at the division bench and decide. The judge order is a nullity.
So, Mr.
I beg to place my lord the division bench judgment.
And under West Bengal non-agriculture tenancy 1949.
Yes.
No, my lord. It is under general non-agricultural tenancy. Definition of non-agricultural tenancy under the State Acquisition Act.
No, you are calling himself to be a non-agriculture tenant under which act?
Under the Estate Acquisition Act, which contains this definition of non-agricultural tenancy.
Of 1949.
Estate Acquisition Act, 49 Act is different. Estate Acquisition Act has the definition of non-agricultural tenancy.
Definition of 53 Act.
Kindly be satisfied, and I have been recorded as a non-agricultural tenant.
Yes, Mr.
Yes. And if 60 and the division bench in the recent judgment of September 2023 has held 6.3, does not apply. Kindly have a look at the division bench judgment, Lord. Or if it's not possible,
which judgment you want us to show?
Justice Tannen's division bench latest, relying upon earlier 4 judgments. And secondly, my land is within the ceiling. If it is within the ceiling, 60 doesn't apply. Kindly look at the problems. Kindly turn to me, Lord.
The ceiling under 14A.
No, that will later on.
6.1.
Kindly, first of all, kindly turn to the 3rd page. The respondent filed a written statement. This is decided here.
Heard Mr. Mukherjee, senior.
পরের দিন রাখছেন
appearing for each other. Please see my
My lord,
The citation
your lordship is fixing it on the
Tomorrow, Mr. Mukherjee.
Now he was claiming himself to be a riot under Section 4 of LR Act.
এটা কি? Affidavit of service. Affidavit of service.
My lord, may I make a prayer about the next matter also tomorrow, not today? Next matter also I am appearing.
Milord, tomorrow, Milord, I have some difficulty. Next matter, I am there.
No, the next
Tomorrow
matter.
Next matter, Milord, tomorrow I have some difficulty.
Wants it to be done.
We keep it on the next week.
No, my lord. My learned senior is perhaps praying that in the next matter, my lord also takes it up tomorrow.
No, Milord, tomorrow I have some difficulty with regard to the next matter. If your lordship takes it up any day, next week, Milord.
Week after next call, week after next call.
স্যার আমার কাল আর পরশু থাকবো না স্যার, একটা বাইরে
আরে
কাজ
ঠিক আছে, কর নাই ভাই, আমি তো আপত্তি করছি।
স্যার 28 বা 1 তারিখ যদি করে অসুবিধা হবে?
28 কেন কল্লোল দা?
1 তারিখ কর, 1 তারিখ।
1 তারিখ যদি করেন স্যার।
1 তারিখ কর।
আচ্ছা স্যার, আপনি একটু জজ সাহেবকে বলুন।
My lord, let me fix on 1st April, my lord.
My lord, let this matter, my lord, remain tomorrow, my lord. There's some urgency, your lordship. And that may appear, my lord, on 3rd April, my lord.
এইটা কি ডিপলি অবলাইজ মানে স্যার, আপনাকে অনেক কৃতজ্ঞতা।
কবে ফিক্স করলো? কবে ফিক্স করলো রে?
স্যার আপনারটা আমার পরেরটা স্যার 1 তারিখে স্যার।
This matter will appear tomorrow and the next matter will appear on 3rd April.
Which matter will appear tomorrow?
এই ম্যাটারটা অ্যাপিয়ার করবে কাল, এই ম্যাটারটা।
এটা বলি স্যার, জাজমেন্ট গুলো একটু লেটেস্ট জাজমেন্টের একটা কপি পাওয়া যাবে? এটার একটা কপি দিতে ওকে। মিস্টার ব্যানার্জি, একটা দাও আমাকে। বান্টি, একটা কপি দাও।
গরম গরম আসছে,
দাও। কোথায় বান্টি দিলে না? বান্টি দাও। হাওড়া কর্পোরেশন নিয়ে চলে গেল।
আমাকে তো দরকার। হ্যাঁ, আপনাকে দিচ্ছি একটা টেন্ডেন্সি কপি ওনাকে দিয়ে দিন, আর্মি কোর্টের তো সাইড হয়েছে। সরি এক্ষুনি
দাও, স্টেটই তো ডিপেন্ড করবে, কর্পোরেশন তোমাদের সাইডে আছে, দাও।
Your Lordship, allow me to mention as urgent matter. Appeal is item number 55 of the today's list. Contempt petition was initiated before the Justice Bharat Daj, and we asked them to matter the fixed day before tomorrow, but he is not allowed. He fixed that tomorrow 10:30. Would you kindly enough to fix the matter for 4:15?
How can we take it up now?
After 4:15, my lord. I'll
bring your other side tomorrow in the morning. Bring your other side tomorrow and say tell us.
Other side also present.
Who is the your other side?
Mr.
Come tomorrow. It is 55. Any other party is there? Item
No.
55 of today's list.
Today's list, my lord.
Mentioning. Yes, we will keep it. We will continue. Have we heard the matter?
No, my lord. First time. That is examination of MBBS student. We have.
Tomorrow 10:30. Yes, we here.
My lord, I'm not the opposite party, my lord. Actually, I have a query of my own. Lord, additional parties in this matter, my lord. Rajiv Promo versus State of West Bengal, my lord.
Yes, Mr. What you are wanting?
Addition of my party, my lord. In this
Has
matter.
it come? Application you have filed?
Yes, my lord. We have filed in and there is an order by Mr. Vishwajit Basu, my lord.
What you are saying, sir?
My lord, we filed in front of learned Judge Vishwajit Basu.
What application you have filed?
Additional parties, my lord.
Then what is your prayer today? Is it appearing in the list?
No, my lord. It's not appearing with the...
So give the CAN number, it will appear along. Furnish the CAN number. Yes. Yes, Mr. Mukherjee.
My lord, I was on, my lord, the vacancy point, my lord. My lord, I had, my lord, almost concluded. My lord, actual, anticipated and future vacancies, what I'd addressed your lordship on, including clause 8, my lord, of the advertisement, which my learned friend, Mr. Shannal, had drawn your lordship's attention to. And I'd cited, my lord, 2 cases. Now, my lord, assuming, my lord, I'm wrong, my lord, in all that, whatever I've submitted, my lord, my respectful submission, my lord, before your lordship says, my lord, that, my lord, a state, my lord, need not fill up all vacancies, my lord. Even I'm assuming, my lord, I'm wrong, my lord, with regard to, my lord, the vacancy, my lord, issue, my lord, on future vacancies, my lord, need not be filled up. My lord, should not be filled up because the recruitment process, my lord, pertained to 2016 and these vacancies were created later. My lord, here, my lord, I, my lord, rely on, my lord, Supreme Court decision 2018. In fact, my lord, I should, my lord, rely on first, my lord, 1993 supplement 2 SCC 600, my lord. My lord, kindly take my compilation of cases, my lord, which I had handed up last time. My lord, that's page 13 of the compilation.
Yes. Mr. Mukherjee, when was the prior to judgment delivered by her ladyship? When was the declaration made? Final declaration of vacancy was made prior there.
Yes, yes, my lord. During the pendency, my lord, of my lord, the first rate, my lord, it was November 2019, my lord. 11th of November 2009.
Yes. 11th of November 2000. Now, what is your argument to that? Suppose 11 November 2000, after that the selection process was struck down with a direction that
To start from a particular point.
particular, but by that time the vacancies were as declared were existing.
Correct.
Not the fresh vacancies.
Yes. My lord, fresh vacancies, my lord, initiation happened on 15th of February 2019, before November. Then, my lord, when November 19, my lord, was declared, there was no objection, my lord, to, my lord, the final vacancy, my lord, which had been declared. Then, my lord, after it was struck down, my lord, in December 2000, my lord, the final vacancies was the same, my lord, as November. Again, there was no contemporaneous, my lord, objection. This has now, my lord, been raised. And, my lord, this was, my lord, and I'd made my submission. My learned friend quite rightly had pointed out, clause 8, that it would include creation of posts, which is why I cited the two Supreme Court decisions. My lord, that might have been given, my lord, but, my lord, to do so would have been illegal because, my lord, they are, my lord, future vacancies and not anticipated, my lord, vacancies.
Yes.
My lord, now, my lord, assuming I'm wrong, my lord, in that submission, then, my lord, my respectful submission, my lord, is, my lord, that, my lord, there is, my lord, no right, my lord, to, my lord, no obligation, my lord, to fill up, my lord, all vacancies.
What is the citation in 19?
Yes, 1993, supplement 2 Supreme Court cases, 600, my lord. Kindly come to paragraph 7.
Is it at what
Yes,
page?
my lord, compilation, my lord, page 13. Page numbers are at the bottom. My lord, the case starts at page 13. My lord, kindly come to, my lord, paragraph 7, which starts at page 606 of the report and page 19 of the compilation.
Yes.
My lord, kindly come to page 607. My lord, 4 lines after placetum E. My lord, compilation page 20. My lord, to put it differently, no right had vested in the candidates on their names having been entered on the select list, and it was open to the government for good reason not to make the appointments therefrom and fill in the vacancies. In a recent decision in Shankoshan Das versus in Union of India Constitution Bench, reiterate that even if a number notified for an adequate number are found fit, successful candidates do not acquire any indefeasible right to appointment. It was pointed out that ordinarily the notification merely amounts to an invitation to apply, and on their selection, they do not acquire. The state is under no legal duty to fill up all or any of the vacancies by appointing candidates for that purpose. Now, my lord, that certainly, my lord, cannot be a ground, my lord, to set aside the entire selection process, because vacancy and reservation is, my lord, what was, my lord, really relied on apropos this. Then, my lord, kindly come to, my lord, the decision which is item 3 in that list, my lord. This is 1994, 1 Supreme Court cases 126, which is, my lord, page 24 of the compilation. My lord, kindly come to paragraph, my lord, 6 and 8. Kindly see paragraph 6, my lord, at page 129, which is page 27 of the compilation.
Yes.
My lord, we directed the stay, my lord. This is, my lord, my lord, there was an interim order in the, so we directed the stay of that part of the impugned judgment under which the state was obliged to fill up the vacancies which arose in the years 89, 90, 91. Directions were, however, issued by this court to fill up vacancies as existing till 1988 promptly. Now, my lord, kindly come to para 8. My lord, this is, my lord, the same, my lord, Shankoshan Das, my lord, which is being quoted. Then, my lord, paragraph 9. We are therefore of the opinion that directions given by the High Court for appointment of impanel candidates according to their position in the merit list against vacancies till 1991 were not proper and cannot be sustained. Now, my lord, another, my lord, quickly, my lord, the last judgment on this, 2018, 16 Supreme Court cases, 195, my lord, which is page 1, my lord, of the compilation. My lord, kindly come to, my lord, paragraph 21, which is page 9 of the compilation. At page 9 of the compilation, which is page 23.
Yes.
My lord, kindly see, my lord, para 21. My lord, last 4 lines, Placidum G. In Vijay Kumar Mishra, this court held there is a distinction between selection and appointment. It was held that a person who is successful does not require any right to be appointed. Such a person has no indefeasible right. Then, my lord, 22. My lord, again, my lord, says the same thing. 23. Having held so, we must also note that the law is well settled, that even though the candidates may not have a vested right of, and the state is not under any duty or obligation to fill up, the state has to act fairly and it cannot act in an arbitrary. Decision not to fill up the vacancies must be taken bona fide and for justifiable reasons. My lord, here, nobody says, my lord, that, my lord, is deliberately not to, my lord, for any ulterior purpose. There is no such case. In fact, my lord, 11 November 1919, when the final vacancy list, my lord, was, my lord, published, even after creation of those new posts, my lord, there was no objection. Similarly, my lord, on 21st June 2021, when the same number was repeated, my lord, again no objection was taken, my lord, contemporaneously. Now, my lord, the only reason why this is, my lord, being urged is, my lord, if, my lord, reservation and, my lord, vacancy, my lord, list, my lord, is, my lord, taken to include, my lord, the vacancies which have been created, do some persons who otherwise don't feature at all, my lord, in the zone of consideration, could, my lord, feature. And that, my lord, as I said, my lord, on a lighter vein, my lord, is, my lord, Rajiv Brahmo's case as the protagonist. My lord. Now, my lord, I come straight away to reservation. My lord, this, my lord, kindly take, my lord, the 2016 rules, my lord, which have been given, I believe, yes, my lord, from, my lord, yes, my lord. My lord, unfortunately, my lord, I marked on, my lord, my loose copy, my lord, on this. My lord, it's also there in Rajiv Brahmo compilation. Yeah. My lord, kindly, my lord, take, my lord. Note that out. My lord, what has been argued, my lord, is that, my lord, migration should not be allowed to the unreserved category before the interview. It's only after the interview is over and we have a consolidated merit list do we, my lord, look at, my lord, migration.
Yes.
Now, my lord, for that purpose, my lord, various, my lord, rules, my lord, have been placed from the 2016 rules. Now, my lord, I, my lord, will also place them and some others to show, my lord, that, my lord, what has been argued before your lordships in effect is that general category is not open category. Now, my lord, kindly have a look at the rules once, my lord. My lord, kindly take the definitions. My lord, rule 2. Kindly see, my lord, in these rules, and this is the next words, my lord, are very important. Unless the context otherwise requires, kindly come to B. Category means, my lord, it's, my lord, category means subject category, medium of instruction category, reservation category, and gender category in each subject group, as the case may be. I'm excluding, my lord, physical education and, my lord, work here. Now, my lord, kindly come to. So, my lord, here your lordships will find where, my lord, unless the context otherwise requires, a definition has been given which says it means. So, my lord, it's not, my lord, inclusive or anything. It's specific. And, my lord, reservation category is mentioned. Gender category is mentioned. Medium of instruction category is mentioned. Subject category is mentioned. And, my lord, subject group is mentioned. What is absent, my lord, is, my lord, the general category. Now, kindly come to interview list. Interview list in respect of SLST means. Now, kindly note, in case of vacancies, my lord, I'm excluding physical education work, a list of candidates to be called for personality test. Now, my lord, kindly note this. Category wise on the basis of merit. This is, my lord, very important. My lord, the interview list is not confined to, my lord, reserved category only or gender category only. Here, category will mean, my lord, the general category or open category. And, my lord, what suggests this is, my lord, that is on the basis of merit. And it's for preparation of the list for the interview. And it gives the ratio of 1:1.4 of the final vacancies. So category here, my lord, with the greatest of respect, my lord, has, my lord, a wider meaning than, my lord, category mentioned, my lord, in 2B, when it uses the expression category wise.
Then according to you, what is the meaning?
My lord, category wise, it will have for open category.
Your argument is that a list of, they will prepare a list of candidates to be called for the personality test.
Correct.
Category wise on the basis of it.
Yes. Now, my lord, category wise, here will include open category, reserved category. Now, in open category, one can have, my lord, persons, my lord, who are entitled to the benefit of reservation. Because an open category, that's the general category, is not a closed category. Supreme Court has said it number of times. And, my lord, I want to make one thing clear. This is the process which has been followed all along, year after year. It's not, my lord, something new which was done, my lord, for the selection process.
But Mr. Just a question,
yes,
because Mr. Shanal's argument was that if you allow the migration or if you create the list at that stage, including general category as well as reserved, then many general category candidates would be ousted from the entire selection.
Correct. Process. Correct. Correct, my lord. It's merit based, my lord. That's why it says on the basis of merit. Otherwise, it would have been no need to go into merit at all.
So you are publishing the interview list category wise on the basis of merit.
Correct.
So then category wise is being...
One is open category. General category law says is open category. It cannot be category as per 2B because then there will be no open category list on merit.
Yes.
Now, my lord, kindly have a look again at the panel. Definition of panel. In fact, my lord, I must show, my lord, merit. My lord, definition of merit also. Kindly have a look at merit list. 2F. Merit list in respect of SLST means, in case of posts other than so and so and so, a list of candidates prepared category-wise on the basis of merit. That is, weightage of TET, academic and professional qualification, and marks obtained in personality test from interview list. This is, my lord, the final merit list, which comes out, my lord, after, my lord, the interview has been conducted. Then, my lord, kindly come to panel G. Panel means a list of candidates category-wise of the merit list equal to the number of final vacancies and includes a panel region-wise on the basis of the option exercised by the candidates. So, my lord, we have category-wise, pre-interview, my lord, for the interview. We have a category-wise for the merit list. We have a category-wise for, my lord, the panel. Now, category-wise, my lord, is used, my lord, in all three. And all have to be placed on the basis of merit. And category-wise in panel, as well as merit list.
Yes.
My lord, is, my lord, general category also, which is open. And there they say you can have migration. But category-wise expression is the same. My lord, is the same for waiting list also. Kindly have a look. 2H. Waiting list means a list of candidates from the merit list category-wise, but not included in the panel. So, my lord, merit list, panel, wait list, all category-wise. And obviously, it includes open category. And, my lord, for interview, also category-wise. So, my lord, it has to have open category. Now, my lord, kindly have a look, my lord, at, my lord, reserved category. Because that is, my lord, the definition. I'm sorry.
When this panel and the merit list was prepared,
yes,
this on the basis of merit, all right, category wise. Now, at this stage, do you segregate the candidates under different groups, or it is one common list? It is not.
No, it's segregated at the time of calling for interview.
No, there was, at the time of interview, there was no segregation because you added all the candidates under open category as general category group. It was not that at the time of interview, 10 persons called from general category.
No, on merit. There's
merit.
An evaluation, so it's on merit. So if a reserved category candidate has got more marks than a general category, he gets included in.
Yes, that is in the interview list.
Correct.
Now, we are asking you that at the time of this merit list, on the basis of marks they get added. Now, do you segregate general category candidate?
Yes, it's only, my lord, general category.
So, segregation is from the preparation of merit list stage. There was no such segregation at the time of.
No, my lord, there is really no segregation. I'll tell your lordship what happens. My lord, we have, my lord, an interview list.
Yes.
My lord, that interview list in the open category, my lord, could have somebody, my lord, who belongs to the reserved category.
Yes.
Because by virtue of merit, my lord has scored more than, my lord, a general category.
Right.
Now, my lord, the interview takes place. Now, the interview, my lord, is for that, my lord, category. My lord, there is no reversal back, my lord, by, my lord, the reserved category candidates. If they score less and general category candidate placed with them who were below them in merit score more, and, my lord, ultimately in merit list they rank higher, then they are higher.
So this on the basis of merit, an open category list is prepared,
Correct.
which is interviewed. After the marks are allotted for personality,
it's again, my lord, on that.
On the basis of merit, you are now keeping open category, including persons of SC, ST who
were already there at the time of it.
As well as other separate SC.
Correct. Correct.
Yes.
Now, my lord, kindly come to J.
But Mr. Mukherjee, how does it meet their argument? That
my lord, I don't have to meet their argument. I have done what is right in law. I have not, my lord, I am not in the open category pushing people who are not meritorious. That is, my lord, the law. My lord, the argument which is made, with the greatest of respect to my learned friend, my lord, is, my lord, not correct, my lord, in law. It is taking place at, my lord, moment merit enters the situation for evaluation, my lord, the migration starts.
Yes.
Now, my lord, kindly come to reserved category. Reserved category means category of reservation in respect of scheduled caste, scheduled tribes, other backward classes, Group A and Group B, and physically handicapped candidates. Now, my lord, vacancy has been placed. Now, my lord, kindly come straight away, my lord, to my lord, 7. Selection to the post.
Yes.
My lord, this has to be read with 3. My lord, I'm not troubling your lordships with 3. My lord, 7. Selection to the post of such teacher shall be made category-wise on the basis of merit, weightage of TET, academic and professional qualification, and marks obtained in the manner, in personality test, in the manner as specified in Part A of Schedule 3. Then, my lord, 8 and 9 I've already troubled your lordships with. Kindly come to 12. Now, my lord, kindly bear in mind, my lord, interview list, my lord, is also on merit and category-wise. As is, my lord, merit list, my lord, panel and wait list. Now, my lord, kindly see here. We were starting from 12-2. Now, my lord, eligible candidates are there. Now, my lord, Central Commission shall verify the validity of TET certificate, academic and professional qualification of the candidates having valid TET certificates, and marks obtained in TET and other academic and professional qualification shall be evaluated in the manner mentioned in Part A of Schedule 2. So, my lord, here, after eligibility is established, an evaluation process, my lord, takes place as mentioned in Part A of Schedule 2. Now, my lord, this is where, my lord, merit enters. My lord, yardsticks for, my lord, determining, and, my lord, the markers for determining merit are, my lord, provided in the rules. This is the evaluation. Then, my lord, kindly read it with 4. The Central Commission shall prepare and publish in their website an interview list with all details of the candidates to be called for personality test category-wise on the basis of merit as mentioned in Part A of Schedule 2 in the ratio of 1:1.4 of final vacancies. So this is, my lord, kindly read this, my lord, with, my lord, 2E, my lord, exactly, my lord, this is what is happening. And here category-wise is, my lord, open category, reserved category. And, my lord, the subsets of reserved category. Then, my lord, we come to subject, gender, my lord, subject group. And, my lord, that is exactly how it goes on. And the Central Commission, then kindly see 5. After interview, the Central Commission shall, from interview list, prepare and publish a merit list category-wise on the basis of merit. Weightage of TET, academic and professional, and marks obtained in personality as per Part A of Schedule 3. Now, my lord, kindly have a look at these 2 parts. My lord, kindly take, my lord, schedule, my lord, 2 Part A. My lord, should be page 11, my lord, in the compilation. If it is,
yes.
My lord, kindly see. Manner of evaluation of academic qualification, including professional qualifications for selection of assistant teachers for upper primary level. Now, my lord, Madhyamik or its equivalent, the full marks, my lord, are 50, 60% or above, and, my lord, there is 10 marks allocated for evaluation. My lord, we get, my lord, 60% or above will get 10, 50% and above, but below 60 will get 8, below 50 will get. So, my lord, there has to be Madhyamik qualification. And, my lord, the marks, my lord, is, my lord, if it's 60% or more, full marks. Now, my lord, higher secondary, +2 stage, pre-university, etc. Again, my lord, same thing. Similarly, bachelor's degree as mentioned under Clause D of Rule 2 of the Rules 2020. Professional qualification, which is, my lord, B.Ed, my lord, is again given 10. And, my lord, again, my lord, awarded marks, my lord, how it is to be done. Either it's, my lord, 3 and 4 or a 4-year bachelor in elementary education. This is an option, my lord. Again, my lord, how marks are to be assigned. And, my lord, TET, my lord, has, my lord, 40. Kindly note, my lord, TET has 40.
Yes.
And should be calculated on percentage obtained. That is, my lord, 100% is 40. And so on.
Now, who are the untrained ones?
They're out, my lord. There's an undertaking to court that they will not be considered. I'll place that.
Oh, it is out.
Yes. There was an undertaking given to court because earlier there was a challenge that how are untrained coming in, because there was a provision, my lord, which said, my lord, if there are no vacancies, if there are vacancies and there are no trained, then you call the untrained.
Oh, that is why I found Mr. Sannal so silent about it. Yes.
My lord, he's just told me that I should, my lord, stop pulling his leg. I have obviously been doing it, my lord, entire morning. My lord, kindly, my lord. Now, my lord, one thing I want to tell your lordships, my lord, there is, my lord, for eligibility, whether it's, my lord, TET qualified or not, there is a concession given to the reserve category. My lord, by, my lord, the NCTE, which has been adopted, my lord, by the state. Because one of the arguments is that, my lord, there is a relaxation in qualification. Therefore, they cannot be put into the open category. In the notes, not in the arguments. In the notes, it's there.
No, in the writ petition there is.
No, nothing. No. These are all, my lord.
Yes.
My lord, I'm not grudging that, my lord. Let it, my lord, because ultimately your lordship's conscience, my lord, has to be, my lord, satisfied. My lord, my lord, I'll adopt all the technical objections, whoever's taken, my lord, by Mr. Bandopadhyay.
That relaxation, Mr. Sannal, did you argue that NCT, which Mr. Mukherjee is pointing out now?
Mark relaxation. TET qualification है, relaxation होइचे बोले, okay, migration होते पारे.
That was
No, that I have not done.
It's in their note, my lord, which my learned friend's note, it's there. That's why, my lord. He's not argued it, my lord, in all fairness. But, my lord, now, my lord, kindly come to, my lord, now Schedule 3, Part A. Kindly see, my lord, how, my lord, this merit list. My lord, it should be page 13, my lord, in your lordships.
Yes.
Selection to the post of teacher, my lord, I'm deleting the portion in brackets, for upper primary level school shall be made on the basis of TET, evaluation of qualifications of the candidates, and personality tests to be determined by the commission in the following manner. So, my lord, TET weightage is 40 marks, academic qualifications, including professional qualifications, is 50 marks, and personality test is 10 marks. And, my lord, appearance before personality test board is compulsory. This is important because several, my lord, persons who have raised, my lord, objection did not. So, my lord, my lord, automatically, my lord, they go out. Now, my lord, kindly note, my lord, the note. Note 1, the academic qualifications, including professional qualification, should be evaluated in accordance with Part A of Schedule 2. My lord, again for evaluation process, my lord, we go back. My lord, 2, my lord.
Part A schedule.
Part A, my lord, schedule. And, my lord, right through, my lord, it's category wise. And, my lord, your one point, my lord, Mr. Mitro, my lord, was seeking to urge, my lord, was, my lord, that the panel formation did not talk about category wise, but panel does say category wise in the definition. So, my lord, 12.7, my lord, my learned friend had relied on. Now, my lord, so in my respectful submission, my lord, the moment the evaluation process, the first instance, after a person qualifies and is evaluated, my lord, the evaluation is done on the basis of merit and merit alone. Now, if general category is open category, my lord, a candidate who is entitled to the benefit of reservation, if he is evaluated, my lord, by the same standards, my lord, is higher on the merit list, then, my lord, a general category candidate, my lord, he, my lord, gets into, my lord, the general category or open category. My lord, the most important aspect of this matter, apropos migration, is to remember, my lord, that general category is open category. My lord, a candidate who's not entitled to any form of reservation cannot migrate ever to the reserved category. But a candidate, my lord, who might be entitled to the benefit of reservation, if, my lord, assessed by the same standards, scores more than, my lord, a general category candidate, my lord, he comes into general category because that is open. There is no, my lord, reservation. And that is a fundamental principle, my lord, of, my lord, articles, my lord, 14 and 16.
Yes.
Now, my lord, if I may, my lord, make good, my lord, my submissions, my lord, with a few cases. My lord, the first case, my lord, is, my lord, the celebrated decision, my lord, of, my lord, Indira Sawhney. My lord, I believe your lordships have a book, but in case, my lord, it's not there, I have, my lord.
Which paragraph you are?
My lord, paragraph 811, my lord. I don't know if it's there, my lord. My lord, we had given a requisition. I don't know if it's come. My lord, we had given it earlier, but not today. My lord, the book is there, my lord. I have, my lord, 2 copies. My lord, I had troubled your lordship's librarians, my lord, to, my lord, get this. Because, my lord, just one paragraph. And this principle starts, my lord, in my respectful submission. My lord, moment there's an evaluation to determine a merit list. Now, my lord, kindly take para 811, page 735. My lord, this is 1992, supplement 3 SCC 217, para 811. At page 735, my lord.
Yes.
Kindly see, my lord, 811. In this connection, it is well to remember that the reservations under Article 16.4 do not operate like a communal reservation. It may well happen that some members belonging to, say, scheduled castes get selected in the open competition field on the basis of their own merit. They will not be counted against the quota reserved for scheduled castes. They will be treated as open competition candidates. And, my lord, my respectful submission is, moment the interview list, my lord, is prepared, my lord, there's an evaluation on merits. The candidates are all being judged by the same standard. In that evaluation, and there is no relaxation in the standards for judging. My lord, in that situation, my lord, with the greatest of respect to my learned friend, my lord, they are entitled to be, my lord, in, my lord, the general category. Now, my lord, I want to give your lordships a case about teacher recruitment. My lord, in, my lord, Vikas Sankhala's case, my lord, this is reported in 2017, 1 Supreme Court cases, 350. My lord, kindly take the compilation. My lord, page, my lord, 85. My lord, it's 2017, 1 Supreme Court cases, 350. My lord, kindly take, my lord, paragraph 19 first, my lord. I'm sorry, my lord. Kindly take paragraph 13 first. Oh, sorry. Paragraph 19.
Yes.
We may point out at the outset that in so far as issue of concession, relaxation and TET is concerned, it has 3 facets. Whether relaxation in passing marks for TET was validly given by the state government in its letter dated so-and-so, and all such candidates belonging to reserved category can be treated as having passed TET on obtaining marks as per relaxed standards. Whether no relaxation of any nature could be given by state government, and therefore it was incumbent upon persons belonging to reserved categories as well to secure 60% mark to treat them as qualified. Then 2, relaxation to the extent of 5% was permissible and provided VDA, and therefore those who secure 55 could be treated as success. This was one of the considerations. Now kindly come straight away to para 80. My lord, page 384 of the report, 119 of the compilation.
Yes.
Having regard to the respective submissions noted above, first aspect that needs consideration is as to whether relaxation in TET pass marks would amount to a concession in the recruitment process. The High Court has held to be so on the premise that para 9A, dealing with such relaxation in TET mark, forms part of the document which relates to recruitment procedure. It is difficult to accept this rational analogy. Passing of TET examination is a condition of eligibility for appointment as a teacher. It is a necessary qualification without which a candidate is not eligible to be considered for appointment. This was clearly mentioned in the guidelines notification dated 11th February. These guidelines pertain to conducting of TET, basic features whereof have already been pointed out above. Even para 9, which provides for concessions that can be given to certain reserved categories, deals with qualifying marks that is to be obtained in TET. That's a person who passes TET examinations becomes eligible to participate in the selection process as and when such selection process for filling up of the posts of primary teachers is to be undertaken. On the other hand, when it comes to recruitment of teachers, the method of appointment of teachers is altogether different. Here, merit list of successful candidates is to be prepared on the basis of marks obtained under different heads. One of the marks is marks in TET. So far as this head is concerned, 20% of the marks obtained in TET are to be assigned to each candidate. Therefore, those reserved categories who have secured lesser marks in TET would naturally get less marks under this head. We would like to demonstrate it with an example. Suppose a reserved category candidate obtains 53 marks in TET, he is treated as having qualified TET. However, when he is considered for selection to the post of primary teacher in respect of allocation of marks, he will get 20% marks off for TET. As against him, a general candidate who has secured 70 marks in TET shall be awarded 14 marks in recruitment process. Thus, on the basis of TET marks, reserved category candidate has not got any advantage while considering his candidature for the post. On the contrary, and this is very important, my lord, moment merit enters, my lord, it has to be on level playing field. On the contrary, level playing field is maintained whereby a person securing higher marks in TET, whether belonging to general category or reserve category, is allotted higher marks in respect of 20%. Thus, in recruitment process, no weightage or concession is given, and allocation of 20% of TET marks is applied across the board. Therefore, the High Court is not correct in observing that concession was given in recruitment on the basis. Once this vital differentiation is understood, it would lead to the conclusion that no concession becomes available to reserve by giving relaxation insofar as recruitment only enables them to compete with others by allowing them to participate in selection process. In this backdrop, irrespective of the circular dated so-and-so, reserved category candidate who secured more marks than marks obtained by the last candidate select in the general category would be entitled to be considered against unreserved category. However, it would be subject to the condition that they have not availed any other concession in terms of attempts except fee and age. And Jitendra Singh, etc., Millard, is referred. Now, Millard, that, Millard, the general category, Millard, is an open category. Once, Millard, a person is qualified, Millard, after that, Millard, the migration takes place, moment evaluation starts, Millard, on merit. Millard, we have, Millard, two division bench judgments of our court, my lord, relating to, my lord, recruitment by the state. My lord, taking into account, my lord, the acts. My lord, I had given, my lord, the, my lord, unreported copies then. My lord, अच्छे एगुलो एगुलो तो दे दाओ ना कॉपी हाँ आगे दाओ आकाश भूयाटा आकाश আরে দিয়েছি তো, কপি আছে তোমার কাছে। My lord, kindly take, my lord, paragraph, my lord, 72. My lord, migration, my lord, is against the same standard. It becomes available, my lord, when we participate in open competition. That's para 72, 73. Prior to that, my lord, it does not apply. That's what para 72. Kindly see 73. In the case on hand, relaxations in age were availed of at the stage prior to holding a final written test. Such relaxations do not have any relevance while determining merits of the candidate in final written test and, my lord, the interview.
Yes.
Now, my lord, another one, my lord, is, my lord, Sahim Hussain. My lord, there, my lord, I must say, my lord, Mr. Shannal has a legitimate grievance. My lord, he was too busy doing matters elsewhere. My lord, he could not, my lord, appear on time. My lord, your lordship sees, my lord, the composition of the bench. My lord, he is the my lord, I needn't trouble your lordships too much with this, my lord. It's, my lord, my lord, para 43, my lord. It's actually 37 to 43. My lord, the relevant provisions of the act, my lord, are there. My lord, moment, my lord, evaluation on merit starts, my lord, they, my lord, enter, my lord.
Para 43.
37 to 43. My lord, I'm.
Yes.
Now, my lord, I come to, my lord, the next point, my lord, about, my lord,
The rechecking.
the rechecking, my lord, re-evaluation. Now, my lord, may I, my lord, put it this way? And this is, my lord, my respectful submission before your lordship. My lord, and I make this concession. If your lordship finds that, my lord, this was in violation of any order, my lord, I won't stand in the way. My lord, your lordships, my lord, because 74 candidates, my lord, are the only ones who have been affected, my lord, by this. Out of which only 3 are, my lord, not directly before your lordship, my lord, have been cited as example, my lord, in, my lord, the pending writs. Really, nobody has come. Because annexure A, your lordship would recall, my lord, page 15 of my note.
Yes.
My lord, the second table, revision of list, that 902, my lord, defaced OMR sheet.
Yes.
74. My lord, kindly take, my lord, out of this, my lord, it, my lord, went to, my lord, 74. So only 74. And, my lord, I haven't yet got the data which was promised, my lord, by all the applicants. अरे दे दिया हमारे रोल नंबर वाइज रोल नंबर दे दिया मैं थोड़ा देखे ना
So, Mr. Mukherjee, just the previous page last line, Rechecking done by the commission.
Yes, this was, my lord, class category mismatch, my lord.
Was 1,
Yes.
2, 559
Yes, totaling marks. And my lord, 902
was defaced.
Yes, my lord, this is what
1463 was the total excluded.
Yes, my lord.
Now, in the next column, out of this total 1463, ultimately 821 came inside, or they were under column J.
No, yes, correct. Your lordship's right, my lord. Now, my lord, the 902, my lord, which is H, my lord.
No, if we, this 902, let us take the figure as total exclusion was 1463.
Correct, my lord.
So from 1463, 74 you ousted them, 821 was included.
Yes, 828, my lord. The bracketed figures.
So, Mr. Mukherjee, do you contend that commission had no jurisdiction towards such rechecking?
No, it had.
It had.
Show us that. Yes, my lord, I am saying, my lord, the way I put, my lord, this submission is, my lord, there might be, my lord, bars, my lord, in, my lord, statute, in, my lord, rules, my lord, regarding, my lord, rechecking. As far as, my lord, appointment of assistant teachers is concerned, there is no such bar. In fact, my lord, the rules would suggest that there is no such bar. Kindly take, my lord, the 2016 rules. Because, my lord, at the end of the day, my lord, we are, my lord.
Because that is the argument of Mr. Shannal as well as Mr. Bhattacharya.
Correct, correct. But what I'm trying to tell your lordship, my lord, is at the end of the day, my lord, this scanned copy, my lord, yes. My lord, after rechecking also, my lord, the whiteness, my lord, only 74 go out of the zone. The rest, my lord, marks, my lord, on the e-server, my lord, e-mark sheet, my lord, for 2015, my lord, tallied.
So this 74 exclusion has been cited as a ground for setting aside the
entire, which I say, my lord, first, it cannot relate to, my lord, the entire selection process. Second, my lord, in any event, my lord, this is something which is not barred. This, my lord, rechecking.
Now, there is presently 1006 vacancies which cannot be filled up.
Good.
Even if the entire list is appointed.
Yes.
Then also, I think the vacancy comes to about 1000.
Correct. There are, my lord, vacancies far exceed, my lord, what, my lord, has been kept out of, my lord, the. My lord, one is to say, my lord, that we don't look at anything and we go by the e-server marks. My lord, I'm finding it a bit difficult, my lord, to say that. And I'll tell your lordships why. My lord, at the end of the day, my lord, it is, my lord, the duty of, my lord, any, my lord, statutory authority or public authority or any authority discharging public functions, particularly in the recruitment process, to, my lord, be satisfied that, my lord, everything, my lord, is fair. What has happened, my lord, is fair. Now, my lord, it is by chance. My lord, I am telling your lordships quite frankly, my lord, the original is not there. Your lordship put that question to me. My lord, but from proper custody, not from somebody else's custody, we get a scan only for 2015. For other state certificates being issued. 2015, my lord, no certificate. There are e-marks.
Then how you scanned which document?
2015 OMR sheet.
Original OMR was
not available.
Then from what material you scanned?
No, the scanned copy was there with me, my lord, which was there. In the records, what was maintained was a scanned copy.
But the original was?
Original is not there. And that scanned copy, my lord, showed, my lord, certain, my lord, portions, my lord, where there were whiteness.
That was how many papers?
My lord, it was, my lord, 902. My lord, that was 902.
That putting white ink was there in 902 scanned.
Correct.
OMR.
Now, my lord, what happens, my lord, when we scrutinize that, we find that, my lord, in the others, my lord, it has, the black dot is not there. So, obviously, there was a black dot there for a whitener to be used. That's the presumption we've made. So, my lord, Giving, my lord, the benefit of that, my lord, we get certain marks. Now, out of 902, my lord, 800 and, my lord,
so this rechecking was restricted to 902.
correct,
The
correct.
entirety of it.
No, 902. That's what I'm saying.
But your affidavit says
No, correct. My lord, 902 is what had the whiteness.
But you recheck the entire.
My lord,
all the members were there. This.
No.
But your affidavit in 24th March affidavit, 20th April affidavit.
Yes. My lord, I checked for TET 15. My lord, there were several TET 2011 which I could not check.
Kindly come to your affidavit of 23rd of 27th of.
My lord, first, my lord, let us see, my lord.
27th of March 2023,
yes, my lord.
paragraph 9.
Yes. Yes. My lord, kindly take, my lord, 27th March.
Yes, paragraph 9.
Kindly see copies of original, including the scanned copies of the original OMRs of candidates who participated in TET 2015.
The previous line, Mr. Mukherjee.
Yes.
After completion of the interviews of
For all.
The task to recheck various aspects of each of the aforesaid 14,052 candidates.
Correct. My lord, there, my lord, it's a TET certificate. There's already a TET certificate. The OMR sheets are not there, which is why the next sentence says, said exercise included a complete reevaluation scrutiny of all relevant documents, including the scanned copies of the original OMRs of the candidates who participated in TET 2015.
So TET 2015 OMR mark sheet of all the candidates.
Yes, and kindly see the next sentence. However, the OMR sheets relating to TET 2011 were not screwed as the TET was concluded long and all candidates have been issued their mark sheet and served. And after evaluation scrutiny of OMR sheets of TET 2000, it appeared that there were 3 missing OMRs which could not further certainly in regard to OMRs of 1463 candidates who went out of the zone. Irregularities include caste category mismatch of 2 candidates, mismatch of marks in case of 559, and defaced OMRs in respect of 902, for which 146 have been treated as ineligible.
So we understand that these OMRs of 1463 candidates were pertaining to TET 15.
Correct.
They were rechecked.
Correct.
And then out of these 14,052 candidates, how many were TET 11?
My lord, several, my lord. I haven't made that list, my lord.
So that was not touched.
No.
TET 15 must have been much more than 1,463.
No, my lord.
This you are saying that we further certain irregularities were detected.
My lord, 1463 were, my lord,
persons who were
correct. My lord, much more would have been, my lord, checked. Correct. Yes. All those who did TET 2015, my lord, they would have been checked. The OMR sheets. My lord, 12,397. I have the figure here.
12,397 were pertaining to TET 15.
2015. And my lord, 2011, my lord, was 1655. Total was 14,052.
So out of 12,397 TET 15, you found 1463 should go out of the zone.
I found, my lord, this is what had happened in the OMR sheets. 9 out of which, my lord, 1463. 902 had, my lord, whiteness.
Oh.
Then, my lord, I tallied 902 with the server marks and giving them the benefit of the doubt, my lord, that, my lord, what has been whitened out was a black spot.
So in this Harvard, which marks is uploaded? In this Harvard marks,
yes.
which you are saying?
Yes, my lord. My lord, it tallies with, my lord, the out of the 902, it tallies with everything other than 74. And my lord, what is important, my lord, to note is no one, my lord, from that 74, my lord, has come, my lord, subject to correction before your lordship. Only 3, my lord, out of those 74, my lord, have been, my lord, referred to as examples, my lord, in the writs.
এই যে 146 এর মধ্যে ডিফেন্স ডেট 2015 এর ডিফেন্স মেমো ছিল
Perfect tally, no? It's zone of consideration.
721 জনকে ডেকে নেওয়া হয়েছে এই যে বাদ পড়েছিল এই 74। Due to this rechecking, actual if anybody is affected is those 74
Correct,
persons who have
74.
been excluded.
Correct, 70.
But Mr. Mukherjee, according to you, as you are
My lord, not just not just 74, also the 559, where there's a mismatch of marks. My lord, page 15 at the top, my lord.
That is why I said that out of a total of 1463, 820
Correct.
and the remaining went out.
Correct. 828, my lord, came back. My lord, the rest, my lord, stayed out, which is, my lord,
which is
600 odd.
74 for
Correct, and 559.
630, 559. 1463 minus this amount. Now this mismatch of 559, this was
my lord, the total. My lord, there's no whitener.
No whitener.
No whitener.
মানে এইটাকে ওই প্রিজাম্পশনে অ্যালাউ করে হোয়াইটনার দিয়েছে বলে বের হয়েছে বলে আমি নিয়ে নিচ্ছি।
And my lord, that presumption, my lord, has worked, my lord, for 828. My lord, where whitener, my lord, had been used, my lord.
So, Mr. Sannal, what is your counter argument to that? Suppose out of 146, let us forget for the whether jurisdictional issue of rechecking is there. Suppose we will consider, but due to this rechecking, what is your counter argument? The prejudice which has been caused, which affects the entire selection process.
My lord, there are, I just repetition, just my lord, there are 3 affidavits before your lordships.
Yes.
In the earlier proceedings, they said the entire 2 lakhs candidates OMR seats were reassessed before Justice Bhattacharya. Candidates were 2 lakhs. Then again, after de novo process starts, they again reassessed entire 2 lakhs. These
lakhs of what?
State candidates of 2015, those who applied here.
So Mr. Mukherjee says much more than that,
No.
because they have rechecked. Date 11 was left out.
No. Date 11 left out.
Date 15. ওটা কত বললেন না পুরো ফিগার?
2 lakhs.
Date 15, 12,390.
12,000 is a very nominal figure. I tell you, lordships. State 20 past candidate applied. Their number is 2,28,000.
Date 2015
applied in this process. 2,28,000. They were earlier reassessed. Marks were changed. that was a ground for entire cancellation of the one of the ground for entire cancellation of the selection process. Justice Bhattacharya's judgment. Division bench affirmed this is not permissible. There are certain grounds on that. Then second, de novo status. Second affidavit says, again reassessed. Then third, my lord, these rechecking or reassessment ultimately confined to 14,000, those who were in the interview list. These 14,000 who are interview list. Out of 14,000, according to them, this reassessment goes confines to defect, mismatch, all that. 1/4, if I'm not wrong, 6-3 candidates. Now, your losses, kindly visualize this. This is public employment. Can there be reassessment confined to only interview listed candidates?
Because he says rechecking has been done in respect of 12,397 TET candidates 2015.
Well, that's an interview listed candidates. Can it be confined to this? Because if suppose
interview, they after screening they have come in the interview list.
That's your
now I am verifying their.
I'm coming to that. Screening based on the basis of my TET marks.
Yes.
Disclosed. Now suppose after screening, your losses kind mind it, they have already reassessed twice. After screening, they confined into 12,000 interview list candidates. Now, suppose this rechecking what they have said, which reveals all these illegalities or whatever, if this is extended to the rest of the candidates, their marks can also be changed. The only argument would be for the commission, they are not before your lawsuits. That's another aspect.
Justice Bhattacharya said, start from 12.3.
12.3.
12.3 is the stage of preparation of the interview list.
12.4 is the 12.3 is the verification.
Now this verification was done. They had the jurisdiction.
Now, here is the point. Verification was done on what basis?
No, that is not a ground in the writ petition, Mr. Chandan. Please do not complicate issues. As if you are arguing that at the time of preparation of the interview list, that verification they did twice, you said. That by virtue of that many were excluded or illegally, arbitrarily it was done. Now, after the interview list is prepared, and when that interview list is proceeded with, they found 1,463 persons. The persons defaced marks.
Kindly excuse me. Then what is the basis of the earlier two reassessment? The first thing, can there be any reassessment? That's the jurisdiction point. That goes, my lord. Now here your losses kindly come to this rechecking. Third time confined to only interview listed candidates.
Yes.
This? Now, my lord, I have twofold of submission on that. Rechecking is being done on the scan copies. The one thing, first they said 902 candidates were found, they have bubbled by whitener. Their first impression that. Then they again recheck and come to the conclusion, this is a black spot. On what basis, my lord? What is the basis of it? They are doing it on the scan copy. Can you do it, my lord? Can anything be done on the scan copy like this? Now, initially they did not favor. Now, for some reasons, they are favoring. My lord, initially they said bubble. That's why they were kept out of this zone. And kindly remind, all these 14,000 candidates were called for interview.
But at that time, you were included in the panel. In the earlier round of litigation, you people were the successful persons.
No. Some of them not. I tell you one or three things. Then your losses 900 out of 902. If I am not wrong, my lord. 8 candidates saved. That's bubbling and odd. Now 74, they say again mismatch. Who are those 74? They are crucified without intimating them. You have given me the mark sheet. I disclosed it. After the interview, you are rechecking it and saying it doesn't match with your server. Who maintained the server, my lord, then? It is the verification stage you allowed me that everything is all right. I didn't prepare the mark sheet. It's given by you. Can you do it at the time of interview stage? Even after the interview. I was called for interview and not. My lord, one thing factually is wrong, my learned friend, with all respect, that the three examples I have cited, they are all before your lordships. They are all before your lordships. Now rest 559 candidates. Some of them also of the appellant before your lordships. What if there is a mismatch with what, my lord? Their server copy with my marks?
Now, what had been the final order passed on your representations, which were considered?
My lord, this was not before at that point of time. These are all revelation during the appeal. My lord, when the first interview list published, they published it in without complying with the provisions of law.
Then, on the basis of the trial court's order, they put the marks.
Then trial court's order in another matter.
Yes.
Thereafter, your lordships. Then other things even they did not disclose. Then when the first, my lord, the division bench passed an order at the time of admission of the appeal, on that basis they disclosed.
Very good. Now, what had been the outcome of your representation? 18,000 and odd representations were submitted.
At that point time when we made the representation, all the disclosures, all these disclosures are not there.
Now, what had been the outcome of that? That had been disposed
My
of?
lord, they are disposed of. My lord, in fact, my lord, as far as Rajiv Brahma was concerned, was that he should get 2 more marks, my lord, in his higher secondary, which was acceded to for the purposes of evaluation.
My lord, I can take your losses, my representation and their reply. Is, my lord, as evasive as possible. I can. শুধু বলেছে ওই অফিসার বলবে ওই অফিসার দেবে
My lord, one indulgence, my lord.
Wait, sir, let us. So, yes, we continue on. Tomorrow you have a problem.
My lord, tomorrow and Friday. Now it has to, my lord. My lord, after, my lord. I was hoping to get, my lord, till 4:30 today. I would have finished, my lord.
Then 27th we are keeping.
27th.
27th is the.
Circuit bench চলে যাবে
We want Mr. Mukherjee. You won't be taking more than half an hour now. It's almost finished.
My lord, I might take longer. Actually, sure. তারপরে পরে চেঞ্জ
27 সেকেন্ড
My lord, may I seek one indulgence? My lord, kindly keep it on Friday. Subject to this, my lord, I'm trying to get a link for a Supreme Court matter. My lord, they wanted me to appear personally. My lord, I'll have it mentioned tomorrow to see, my lord, if I can, my lord. Otherwise, my lord, it has to, my lord.
We wanted to finish it because these.
I know, your lord, but my lord, my learned friend also gave notice that he wasn't going to be there, my lord, for, my lord, that entire week, my lord.
That is selective.
So, my lord, my lord, have.
Week, my lord, I can. I will be here.
Friday week.
Good Friday. Good Friday. My lord, 20.
মনে রাখলে হবে? My lord, after his new leadership roles, my lord, he is forgetting other religions.
Unless the other religions remind me, why should I?
So now the religion will come to you.
My lord, last location was directed me to name, denomination, roll number. Some of my friend, my lord, they also handed over to me, and some of my friend, my lord,
application.
Yes, application roll number.
The list terms of your lordship.
My lords.
So, my lord, and another thing is that some of my friend,
my lords,
they will be tomorrow.
Okay, regarding
27th.
Record of
My lord, 27th, I'm not there, my lord. That week, I'm not there.
You are not there?
Not at all. 28th, my lord, no, my lord. I'm that whole week, my lord. I'm not there. My lord, I need a break, my lord. Kindly, my lord. Otherwise, my lord, I'm sorry, my lord. I thought I'd, my lord, finish.
কি লিস্টে ছিল? তো তোরা শুধু প্রিপেয়ার করতে পারিস না কেন? ওরা দিয়ে দিচ্ছে, আমি পাচ্ছি না কেন? এত মানে কতদিন বাদে এটা বসলো বলতে বেঞ্চটা? 4 দিন কেন? 4 দিন ওরা তো আগেও চেয়েছিল।
Next week and May.
We keep it on Friday. Let us see how.
Yes, my lord. My lord, my only thing is subject to my getting that link. My lord, I am told, my lord.
You are not sure on.
I'm not, my lord, because I was asked to, my lord, appear. My lord, I will, my lord, request for a link.
You tell us you agree to a date, we shall take it up on that date. We want to finish it off as early as
My lord, any day, first week of April, my lord.
Week of April, Justice Chatterjee is not there.
Oh.
Circuit bench.
Circuit bench.
You agree to a date. We want to finish off the matter as early as our idea is that we can conclude the hearing prior to this next week.
My lord, tomorrow unfortunately is not possible for me.
Now,
And
you, Mr. All the parties are here. You please, then we consent. We set up the date. Because
Mr. Secretary told that next week.
My lords. My lords.
Yes, agree to a date.
My lord, can.
For the 15th.
15.
हाँ ठीक है 15th is fine.
15th subject to the business.
Yeah.
আমার এই ফ্রাইডে তো
বলে দেন
15 April. 15 April আমরা
হ্যাঁ 15th April ঠিক আছে।
Then 15 April.
16, 17, 15, 16, 18, 19, 21, 22, 17. We are keeping it on 17th
I'm grateful,
at 10:30.
Very well.
Because we have another matter.
No, my lord, that's the best, my lord.
On consent of the parties. On consent of the parties. List the matter for further consideration on 17th. Oh, it is 17th, na? On 17th as fixed at 10:30.
My lord, I'm handing over your officer, your lordship.
My lords.
Those 2018 amendment, your lordship.
My lords, I have filed one application, my lord. Application, my lord, CAN 136 of 2024. My lord.
I'm handing over the list.
Yes, thank you.
The poster with the gate.